I'll have it in preliminary hearing list. You find out. Preliminary hearing list on.
25th.
Yes. All mandamus matters, you can file a memo saying that this is mandamus, we'll take it out of. Yes. Go.
Serial number 1, P. Natraj.
Appear for the petitioner.
Okay.
Take out notice.
He didn't say that.
AGA.
Start for interim order, my lord, because after lapse of 45 years, my lord, they have filed the application for change of Kata.
No, now it's already in their name.
No, my lord, it is in our name. We have produced the RTC extract annexure D series, my lord.
AGA accepts notice for the respondents, emergent notice for the private respondents. There will be an order of status quo regarding revenue entries.
Much.
Serial number 2, Maruti TV.
My lord, 9 gunta land has been granted in favor of the
No, correct.
petitioner.
Correct. It is premature that annexure H.
Please, my lord.
That's only it's still whether they're going to file appeal or not, we don't know. You'll have to wait.
For that reason, my lord, we have filed the
Correct.
petition.
We
before
can't
this court.
stop them from taking a decision.
My lord, in adjacent land, my lord, in very same survey number, the Kata and the RTC have been entered, my lord, in their favor. He is also one of the similarly situated person, my lord.
Correct. If they pass an order, then only you can challenge. We can't prevent them from taking steps.
My lord,
You have produced the adjacent.
annexure H issued by
what-
the Tahsildar, my lord, itself is illegal because, my lord, adjacent landowner, my lord, already taken the RTC entry, my lord. Instead of entering the RTC and revenue, my lord, entry, so he issued the like that endorsement, my lord. He referred the matter only, not issued the endorsement.
Correct. How can we prevent them from doing it?
But even till the date, he is not taken any action, my lord, on that annexure H. But annexure H itself is illegal.
That we don't know. That we have to see.
When the other adjacent landowner, my lord, have got the RTC,
Let us see.
question of issuance of H is does not tolerate.
Let us see. AG accepts notice for the respondents. Stand to be taken after completion of instructions. Yes.
Please.
3, Basant Raj.
For the petition of this matter, my lords.
Veena Raike.
For lapse of 45 years, the revenue appeal was prepared before the third respondent.
No, now the entries are in.
Entries are changed after the order of the assistant commissioner in their name. I sought the stay of revenue entries, but MR, which were effect.
Now the entries are already in their name or no?
Earlier it was my name, now in their name. That's the reason I sought.
Correct. That then I'll issue notice. I'll
My lord.
keep it. How can we pass ex parte order? It's in their
My lords,
name.
for a moment, it's order against the dead person. Page 26, my lords.
Page?
Page 26 is the assistant commissioner orders.
Now first it was standing in your name.
First, earlier, since 1983, the revenue entries were standing in my name.
Now who challenged it?
R7, seventh respondent has challenged the revenue entries of the year 83, 84 and 97, 98, which were standing in my name.
In which year he has challenged?
In the year 17 and 18, Lordship will get in page 26, my lords.
Now he is claiming on what basis?
They are claiming that it was their ancestral property. In fact, my lords, in the year 1978, in page 64, I have produced the RTC entry. Though Rangadam Shetty name is reflecting, the extent is shown as 00. He was having no property in this said survey number. Lordship, page 64, my lords.
Yes, now the AC's order.
AC, my lords. If your lordship takes up page 26, my lords, the parties,
Who's dead now?
my lords,
Who was dead?
R4, R5, R7. I have produced the death certificate.
As on the date.
As on the date of the paper, they have taken paper publication on 4/3/2021. As on that day, my lords, I have produced the paper publication also.
No, just 1 minute.
Please.
4, 6, and 7 were dead.
Dead, my lords. I have produced the death certificate in page 65. Venkataramanappa, page 65, my lords.
Yes.
Venkatramanappa was the
This next.
next, page 67, Bolappa.
When did
Next,
he-
68, Veerbhadraya, R4, died on 10/8/18. Veerbhadraya died on 10/8/18. Bolappa died on 17/4/19. The impugned order by the Assistant Commissioner was passed on 16/8/2021.
No, correct. Now,
Please, my lords.
what is the interim order you want? We can direct them not to create third party rights.
Please, my lords, that's all.
Then counsel for the petitioner submits.
Even I produced the invitation also.
Then counsel for the petitioner submits that before the assistant commissioner, Veerabhadraya, Rajappa, and
Bolappa, Venkatramanappa, and Veerbhadraya.
Veerabhadraya, comma, Venkatramanappa,
R457 before the Assistant Commissioner.
Venkatramanappa, and Bolappa, who were respondents,
457 before the Assistant Commissioner, third respondent.
were dead as on the date of passing of the order, and accordingly, order is a nullity. Subject to further consideration, noticing that the revenue entries are already in the names of the private respondents. The private respondents not to create third party rights. AG accepts notice for the respondents.
1, 2, 3, 4, 5, 6, 1 to 6, my lords.
1 to 6, emergent notice to the private respondents.
Please, my lords.
4, Shauri HR.
Sorry, for the petitioners.
Take out
Petitioners are the
notice.
owners,
Take out notice.
please. 1 to 4.
AG accepts notice for respondents
1 to 4.
to
4.
1 to 4. Emergent notice to the fifth respondent. IA 1 of 25 is allowed. Petitioners dispensed with production of certified copy of annexure B, subject to the undertaking that certified copy would be produced in due course.
5, Nagesh, yes.
Take
Petitioner,
out notice.
Will take out notice, my lord. Now, the revenue record standing in the name of respondent number 5 and 6. Based on the said revenue records, they have created two sale agreements.
Correct. So what is the relief here? Not to create third party rights.
No, my lord. We sought a stay of the Assistant Commissioner order as well as Deputy Commissioner order.
Correct. Now since 2013 entries are in there.
My lord, may kindly peruse. We have not made as a parties in the appeal filed by the respondent number 5. They filed against only Tashildar. They have not made me as a party in their appeal. Page annexure C, annexure B, may kindly peruse, my lord, 19, page number 19, my lord. Sunandamma Dhanlakshmi, they are the respondent number 5 and 6, my lord. Against Tashildar only they filed.
Now they sought for
They sought for changing the revenue records in their names. The land originally granted in favor of my father. Previously, my father,
correct. Before that, in whose name it was?
it was in the name of Muniswamy.
Not in your name.
My name is reflected at page number, may kindly peruse, my lord. We have produced the revenue records at annexure E, page number 25, may kindly peruse.
As on the date of annexure B, in whose name it was standing?
It was standing in the name of Sunandamma and respondent number 5 and 6, my lord.
As on the date of
They seek divide of the land in question, 10.5 quintas, 10.5 quintas ಮಾಡ್ಕೊಡಿ ಅಂತ ಇವರಿಗೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಪ್ರೋಚ್ ಮಾಡಿರೋದು ಸ್ವಾಮಿ. 21 quintas granted in the name of my father, that is annexure A is the grant order, my lord. Annexure A is the.
Who are these two people?
These two people, my father's brother, ಅವ್ರಿಗೆ ಸಂಬಂಧಪಟ್ಟ. I have produced the family tree, may kindly peruse their names reflected at page number 35.
No, correct. Now, after that, what happened before the DC?
After passing the order by the assistant commissioner, we approached the deputy commissioner. Deputy commissioner holding that ಇಲ್ಲ ಅವ್ರದ್ದು ರೆಕಾರ್ಡ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಹಾಗಾಗಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ.
Correct. So we'll issue notice. We'll direct them not to
May
create.
kindly, just for a moment, kindly peruse the two documents I have produced before this honorable court, which reflects a sale, two sale agreements have been created with respect.
We'll direct them not to create third-party rights. AGA is directed to accept notice for the response 1 to 4. Response 5 and 6 not to create third-party rights. Not to create any further third-party rights. Yes.
Great.
6. Mahesh, yes. I'll take notice.
Yes, take out.
This matter,
AGA is directed to accept notice for the respondent. Stand to be taken in writing within 2 weeks. Let them take the stand in writing.
7. Prashant PL.
Take out notice. Office objections are kept in abeyance. Take to the undertaking that a better copy of page 52 would be furnished at the time of hearing of the matter if relied upon. What about office objection 2?
so both are same, my lords. Endorsement, another is endorsement, my lords. H and J, my lords.
No, second office objection.
Please, my lords. So that's also
All pages of annexure B.
annexure B, my lords. So annexure B is, my lords,
This objection is all pages of annexure B.
no, annexure B is this Imbaraha, my lords. But
Huh?
that's a better copy, my lords, have produced. And it's an given by the state government.
Not numbered the annexures properly. Page 46 is one annexure.
Please, my lords.
47 is another annexure. You have not numbered it only.
Same, my lords, Imbaraha.
48.
Do one then.
48 is another annexure. You have not numbered it.
Same, my lords, it comes along with Imbaraha, my lords. It starts from 46, my lords. It's continuation. They say that temple is, it's a Mujarai temple.
Office objection seal number 2 is kept in abeyance.
Please, my lords.
Yes. Take out notice. Issue notice. AGA accepts notice for the respondents 1 to 4. Emergent notice to the fifth respondent. Yes. Copy you give copy.
My lords, till then, my lords, let's status quo on the property, my lords. My lords, annexure, my lords, HPB seen, my lords. My lords, there is 4 lakhs has been granted as Mujarai funds, my lords.
When is the tenancy order? When is tenancy?
82, my lords, 82, they say, my lords, it says, my lords, one kind submission, my lords. Till then, there was not at all interference, my lords. My lords, 4 lakhs, recently, my lords, 4 lakhs has been granted by the government, my lords. If it had been, my lords, really granted to him, why the funds would have been granted, my lords? So right in front of,
Find out. Let them
please, my lords, till then, my lords, he's constructing,
party order. How can you give expert?
is constructing right in front of the temple. my
Maybe
lords.
how many years? You're come
Now,
challenging.
now he has come back. my lords.
Maybe.
Illorgu no, ಏನು ಇರ್ಲಿಲ್ಲ.
Order is of which year, sir?
My lords,
82.
we say it's a bogus, my lords.
That
An
means-
endorsement, my lords.
That the government will look into.
My lords, till then, my lords, status quo, my lords. Till then, status quo, my lords.
No.
My lords, my lords, the photos will be seen, my lords. So
That's
what is
for the
photos?
government to take. No, it's a government property, isn't it?
Please.
So I'll keep it open. If at all you find anything, it's for you to.
Grateful, my lords. Till then, there is status quo on the.
No, I'm not passing any order. You can't come after 30, 40 years.
My lords, till then, we have no interference from the Archak, my lords.
What we can do? Order.
Now he has put up
The
construction.
record
Try to
shows,
put up construction.
record shows it's in his name for past 40 years.
No, my lords, no, my lords. The
When is the
RTC,
tenancy right granted to him?
the RTC changed, my lords, in his name.
When was the order passed? 82. 82 is it?
ಅದು ಆರ್ಡರ್ ಅಲ್ಲ my lords, that
That we
there is
don't.
no, my lords,
Then
there
let
is
the
no
government take
signature
a-
of the
Let the government take a stand. I will not.
till
permit-
next state of hearing, my lords, is the appearance, my lords.
Yes,
Because
that-
otherwise he keeps on constructing on the over the in front of the temple, my lords.
If the state finds any illegality, it's open to the state to take appropriate action as is permissible in law.
Grateful.
Yeah.
8. Nageshes.
Lords, land has been granted by the Mysore Taluk Land
AG is
Tribunal.
AG is directed to accept notice for the respondent. This is the matter in preliminary hearing list.
A date, any date.
First,
Endorsement has been issued and go on, my lord. So next week, your lordship.
December 9, Sridhar K. 9,
Pass over.
10, Sagar B.
The petitioner has brought the owner of the land bearing serial number 161/6. Lord, as per annexed A, Lord, sale deed dated 3/6/2024. It's a registered sale deed. Lord, after Lord purchasing the property, Lord, I approached the Tahsildar Lord for MR entry. Lord, the Tahsildar Lord, instead of doing MR entry, Lord, based Lord, annexure B, page 27, Lord, a notice is issued stating that the transaction is Lord, objectionable, which he can't say. Lord, annexure B, page 27 is the notice. Lord, I appeared and I brought to the notice of the Tahsildar that I have purchased the property and registered sale deed, and it is his duty to Lord to do MR entry as per acquisition of rights under 128.
So correct, now they are saying
Yes,
that it's in violation of Land Reforms Act, non-alienation clause.
Lord, is in fact, Lord, a question came before the sample court. Kindly see, Lord, the next year, Lord.
Okay, let us find out.
Yes,
Now you just find out.
yes, Lord. In case, yes, your Lordship, Lord, said that suppose if the land is purchased, Lord, without prior permission of the Deputy Commissioner or the other competent authority, Lord, what is the Lord remedy for the purchaser, Lord, who approaches Lord the Tahsildar for MR entry? This very question, Lord, came before the sample court. Kindly see next year, Lord, page 36. The relevant discussion is on page 39. On reading section 128 of the Land Revenue Act, this court is of the view that section 128 does not contemplate or does not confer power on the revenue officers to examine the correctness of the sale deed, whether sale deed secured by a person is voidable or void or ab initio, which falls beyond the scope of inquiry under section 128 of the Karnataka Land Revenue Act. If the revenue officer once receives a report in regard to the acquisition of rights under the registered document, he is bound to effect MR entry aligning with the conveyance indicated in this rule. It is in this background, Lord, this court has examined. Worst come worst, Lord, the paragraph 9.
Yes,
The
yes.
authorities at best, Lord, impose only, Lord, penalty.
Just find out.
Yes.
AG accepts notice for the respondents. State to complete their instructions. This is the matter in the preliminary hearing list. 2 weeks admiral date.
Please, Lord, till then stay up next year, see proceedings the next year, see, Lord. Now, the application for MR entry is kept pending.
So let us see. Once they take, we'll dispose
Please.
it off here.
Lord, one office objection is there that the office has raised objections that my vendor is not made a party. I am not made, I am not seeking any relief against them.
Office
So last may
objection
kindly,
is
Lord, time being.
kept in abeyance in light of the explanation of the council.
Lord,
Now, yes, give a copy. Now, their only contention is that mutation has been refused on the ground that there's some violation of Land Reforms Act. So they're saying that you have the power independently to take action, but you can't refuse to effect mutation.
Lord, at least stay for this period, Lord, because
So let
the
us see.
kata will not be transferred because it is bound to, Lord,
Correct. So that will pass an order.
please.
3rd of December. 11 PM Sidmalappa.
In this case, the property was granted in the name of the petitioner in year 1977. And Sagoli cheat also issued in year 1997. The private respondent, please lordship, they have claimed that they are purchase of the property in the same survey number, but they have came near the property. I filed the suit, please lordship, and subsequently they also filed this suit. But the Tahsildar was affected the kata in her name, that was challenged by me before the Assistant Commissioner and DC.
So what are the two writs now? Which are the two writs? 11 and 12. 11.1.
Please,
Which is the
both
which is
were same set of facts, please lordship.
Which is what is the first writ and what is the second writ?
Both the facts are the same, please lordship. Both the matters are the independent persons that are granted in their name.
11.1 notice must be issued.
11.5 notice ಆಗ್ಬೇಕು.
you'll have to comply with the office objection 11.1.
Please, I will do in the needful in them.
11.1. AG is directed to accept notice for respondents 1 to 4. Emergent notice to the private respondents. Office objections to be complied with in the interregnum.
With respect to revenue entries concerned, status quo may be granted. I am in 1977, I am in the possession of the property. They have claimed that they have purchased the property. The suits are pending. One suit filed by me for permanent injunction, another suit filed by them for suit for
Now
declaration.
the revenue entry as on date is in whose name?
It is in my name from 1977. The Sagoli cheat was issued in my name.
No, correct. Now he claims through a registered sale deed.
But it not belongs to my property. I have the granted property in year 1977, please Lordship. That is, with regard to revenue entries, status quo may be, it is not affected to both also, Lordship. They cannot take that into their hand and interfere my position, please Lordship.
Where is the order?
The order is annexure E and F, please Lordship. Annexure D is the Tahsildar order, please Lordship. In page number 30, please Lordship, in first matter.
Page 26 is the,
26 in the second matter, please Lordship.
no, first, take the first file.
First file is in page number 30, please Lordship. Unnecessarily ಇದನ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ನೋಡಿ ಮಾಡಿ ಅಂತ that is given a direction. That is a AC was passed the order, please Lordship.
No, he has purchased from whom he has purchased? He has purchased from whom?
She purchased from they have not mentioned in the, they have says that they have purchased the property, please Lordship.
No, the earlier MR is cancelled.
Please
And
Lordship.
matter is remitted for consideration.
Press consider that now if the MR is affected in their name, please Lordship, that is a
There would be an order of status quo to be maintained regarding revenue entries as on date.
in both the matter, please Lordship.
Common order sheet.
Great, please.
Serial number 11 copy may be served on us, my lord. It's not been served.
I will search, please.
11.
Now itself I will.
12, Madhukar MD.
For the petitioner, my lord. I'm challenging the order of the appellate tribunal, my lord, remanding the matter to the deputy commissioner. And the order was passed under section 95 of the Karnataka Land Revenue Act, converting the property from agricultural use to non-agricultural use. Then, my lord, that particular order came to be challenged before the appellate tribunal. The appellate tribunal has remanded the matter to the deputy commissioner to consider this particular matter with reference to the two documents, my lord. My submission is that, my lord, the conversion order falls under a different category. It is an administrative order. As per section 24 and 25 of the,
Come up last.
yes, my lord, similar matter, my lords have already stayed, my lord.
What is it? Could it? No, but what are you challenging now?
The order passed by the appellate tribunal, my lord, remanding the matter to the deputy commissioner. My submission is that, my lord, deputy commissioner has no power. Once he passes an order, he becomes a functus officio under section 95. And he has no inherent jurisdiction with regard to this particular matter under section 25 of the Karnataka Land Revenue Act. With reference to any other matter, my lord, which is a quasi-judicial power of the deputy commissioner, he can exercise his jurisdiction under section 24 and 25 of the Karnataka Land Revenue.
So you are saying that the KAT must decide either way.
The KAT has to decide either way, but they cannot remand the matter to the deputy commissioner.
because it's only an administrative function.
Yes, my lord, that is an administrative order.
I think serial 15 also similar.
Yes, the serial number,
In 15, my lord, I appeal for the cavator. And here, my lord, there is an order of conversion without notice to the.
serial number 15,
Now, have you challenged this order?
Well, I have challenged the order of the deputy commissioner because my lord, I am the purchaser to an extent of 6 guntas of land. Now, my lord, the facts of this case is like this, my lord. The land in question was granted land.
No, now you have separately challenged the same order.
Same order. All the different purchasers challenge the order passed by the deputy commissioner ordering conversion of the land which were purchased from the petitioner.
Okay, then we'll
The
call,
deputy,
we'll call both together
Yes, my lord.
and then we'll hear the matters.
Together, but there is no need for Rashtrapati tomorrow, my lord. There is no need because this matter remanded. The deputy commissioner has to give opportunity to me also because I am the purchaser. Sale just stands in my name.
No, they're contending that the DC, it's only an administrative function. So right
It
or,
can't be, my lord.
right
This
or
is an
wrong,
order, Rashtrapati similar order under section 95 conversion order on the request made by the petitioner. He has got the land converted, which has been sold in my favor.
as on the date of conversion, it was sold to you.
Yes, before that. Opportunity, then once I have to prefer an appeal. I sought the leave of the appellate tribunal. Leave was granted, and I was permitted to challenge the order passed by the deputy commissioner insofar as my land is concerned.
No, he's only saying that KAT should have decided itself
It can't be
instead of remanding.
unless the opportunity is given to the authority which is competent to pass an order of conversion. How can the deputy KAT decide the matter, Miller? Rashma kindly appreciate because opportunity is given to me whether I am the owner or not. Who has to decide? It is the authority which is competent to pass an order of conversion.
Okay, we'll hear the matters.
yes,
Tomorrow, Rashma kindly.
my lord,
All
only
the
my
matters can-
difficulty is that, my
all the
lord,
matters can be
the
brought
difficulty is that all these cases, my lord, the deputy commissioner has reserved the matter, my lord, to pass the order.
Already.
He did not, we made a request that we have already challenged. He reserved the matter for pronouncement of the order. That is the difficulty.
You have
Ultimately,
Sorry.
my lord,
you have participated in the proceedings.
I appeared before the authority, my lord, and I requested to defer the proceedings till the disposal of the writ petition. He has reserved all the matters, my lord.
Correct, but let him pass an order, we'll see what.
My lord, my submission is that, my lord, the authority which has no jurisdiction authority cannot proceed with the matter at all. One is appellate tribunal has to decide it. The appellate tribunal cannot confer because the jurisdiction is only by way of a legislation. It can't be by way of a judicial order. And appellate tribunal has to decide it, my lord. I am not.
Let us see, let him not pass orders till the next.
Yes,
week.
ma'am.
We'll
Yes,
hear it later.
Yes, ma'am.
an order passed in section 95 converting is an appealable order. The appellate authority, that is appellate tribunal, has come to the conclusion. See, you have got the land converted, though you had sold so and so extent in favor of so and so person. And the person in whose favor the sale deed is there, they had preferred an appeal. Therefore, the appellate tribunal, being an appellate authority, as against the order of conversion, remanded the matter. Here, section 25 doesn't come at all. I can understand if the deputy commissioner is exercising independently, that is even after the order under section, it is not under section 25. It is an order. Of course, the appellate tribunal has remanded, rightly has remanded. He has to reconsider it. Otherwise, no opportunity. I cannot go anywhere because appellate tribunal.
No, we'll just, now you take up this WP 32991 filed by him. Now, the
Order is common in all, though it is a separate order.
So correct. Are you saying that as on the date of conversion, in all of in that conversion order, annexure
J in my.
Annexure L, my lord.
Annexure J in my petition. There was already a sale. My lord, he was owner to an extent of 3 acres. Out of 3 acres, my lord, Rashmi is annexure J in my petition.
Sorry, my lord, J, my lord.
Annexure J in my petition.
page.
J, annexure J.
My lord, if my lords are holding 33054, my lord, page number 81, my lord. May I make my submission, my lord? Then it would become easier, my lord. If my lords permit, I will make my submissions. My lord, this is an order passed on 19/4/2022, my lord. This particular order, before passing this particular order, my lord, there were certain judicial proceedings, my lord. And proceedings under the provisions of the Karnataka SC/ST Act was initiated after selling this property against me, my lord. At that point of time, there was an understanding between us that they would not get that particular land. I have to return the sale consideration. I have returned the sale consideration, my lord. Thereafter, my lord, I pursued the proceedings before the AC. I lost it, my lord. I pursued it before the PTCL proceedings. Then I succeeded. On the basis of that particular orders, my lord, which was up to division bench, the order was passed. I have succeeded. Thereafter, my lord.
So you are the purchaser.
I was the first purchaser, my lord.
So the proceedings were rejected.
The resumption proceedings was initiated.
Were rejected.
The resumption proceedings was rejected, my lord. In the interregnum, my lord, I had sold this particular property to the various persons, my lord. Then they came to me saying that we don't want to get into this particular proper dispute, and they wanted return of the money. I have returned it, my lord. I have entered into an agreement. I have also initiated a suit, my lord. And in that particular suit, my lord, I have sought certain relief against them, my lord.
No, that the agreements were registered or sale deed?
No, my lord, it is only an agreement of sale because the entry in the revenue entry, government name was coming, my lord. For that reason, I could not able to get the property registered, my lord. That is the difficulty what I had, my lord.
Now the agreement to sell were registered?
No, my lord. It's an agreement for cancellation of the registered sale deed, my lord.
In my case, there is no such registration.
No, let me complete.
Agreement for cancellation
of the original sale deed. So that was entered into.
Now what happened to that? You have sought for, you filed a suit?
I have filed a suit with reference to those proceedings, my lord, because they have already received the money back also.
What is the stage of that suit?
That particular stage they have appeared, my lord. Now the matter has to be, the issues have to be framed, my lord, and the trial has to take place. In some of the cases, trial has started, my lord.
But how have you paid back the money?
My lord, by check I have paid, my lord. They have received the substantial amount they have received. In one respect of 1 or 2 cases, my lord, they have received the part of the amount. The check has been bounced, my lord. They have initiated check bounce proceedings against me, my lord. They have received the money, my lord.
That's a matter finally to be decided
by the civil court, my lord. Civil court. My only submission is that, my lord, the section 25 confers a inherent power to the revenue authorities, my lord. If an order is passed under section 95, it is an administrative order, my lord. It is in such an event, my lord, revenue authority will not get a jurisdiction under section 25.
So we'll say that the orders to be passed by the DC would be subject to orders passed in the writ petition. Let's see what he does.
My lord, my lord, my submission is that, my lord. The reason is that, my lord, in A.R. Antule case, my lord, the Supreme Court has
Let us see.
The power cannot be conferred, my lord. My only request is that, my lord, in such an event, my lord, it would be difficult. Let him, I will argue the matter tomorrow or day after tomorrow, my lord.
Now he's going to pass some order where we'll make it subject to the outcome of this writ petition. We'll hear this matter.
My lord, my only request is that, my lord, in another case, my lord.
Jurisdiction, he has no jurisdiction.
My lord, I had placed some of the judgment of the division bench, my lord.
That we can't decide that question at preliminary hearing stage.
My lord, that was on last date, my lord.
In the event,
yes,
matters are not reserved for orders. In such of the matters, will state.
My lord, the reason is the reserve in the sense I have not been heard at all. The reason is that I made a request, and within 2 or 3 hearings, he has reserved the matter without there being any hearing. And the order sheet speaks about it. At least a fair opportunity should have been given to me.
Okay, let us see. Let him not pass orders for the time being.
Yes, my lord. Yes, my lord.
Permissions. Page 35 of the impugned order, page 35. Page 35. Lordship is trying to come to the column. The same transaction made by the petitioner. Page 35, Manna. Usha Patel, 6 gunta sold. Shrikante, my client, 6 gunta sold. Venkatesh, 7¼ gunta sold. Padmavati, 6 gunta sold. Therefore, from the above sale transaction, the respondent number 2 had right only over so and so, but he has got converted the entire 3 acres of land without, by suppressing the material fact, by playing fraud, got the land, entire land got converted into non-agricultural purposes.
No, are you saying that out of 3 acres,
Yes, madam.
even if we were to leave out 2 acre, 14 guntas,
He's entitled.
Yeah.
That he's entitled. I am concerned, 6 guntas of land.
that is retained with you.
Yes.
There are no revenue records.
My lord, he has retained 2 acres, 14 gunta. By selling these extents. I am concerned with my 6 guntas of land, that's all. I am not
Now you are the owner of the land.
owner of land to an extent of 6 guntas of land, purchased in the year 2010 under this is sale deed.
Now this sale deed relates only to 2 acre, 14.5 guntas.
No. My lord,
What
he
was
had-
sold? What was sold?
What was sold only 6 guntas, 706 guntas.
That
Only
is
this extent.
2 acre, 14.5
The
guntas.
petitioner has retained 2 acres, 14.5 guntas. He should have got the conversion only to an extent of 2 acres, 14.5 guntas for the reasons that he had sold these extent.
The sale deeds
Ah,
total to this amount extent shown in the table.
yes, madam, only to that extent.
That is the only sale deed that you have
Yes,
executed.
madam.
The remaining you had retained.
No, he has retained. He is the petitioner. He is the owner. The remaining 2 acres, 14.5 guntas. From whom I had purchased.
You are the owner of total extent of
3 acres.
acres.
3 acres.
Yes, my lord.
Now you sold to him
In 6 guntas in 3 trenches and 7.5 gunta another trench.
but that comes
That comes around 22 guntas, my lord. 24 guntas, my lord.
24 guntas.
Yes, ma'am.
Now this sale,
Yes, my lord.
you entered into an agreement to cancel.
Yes, ma'am.
And that is now pending in the suit.
Civil court. My lord, if I won't succeed, my lord, the land belongs to them, my lord.
This is the 24 guntas.
Yes, ma'am.
Now the conversion is for which extent?
The conversion is with respect of all the property, including this 24 guntas, my lord.
That is entire 3 acres.
Because the challenge was with respect of entire 3 acres, my
No,
lord.
correct. Now
Yes, ma'am.
their challenge,
Yes, ma'am.
their interest is only 24 guntas.
Yes, ma'am.
Leaving out the 24
My lord,
guntas,
that-
just one.
Yes, ma'am.
Leaving out the 24 guntas,
Yes.
what remains in 3 acres?
Yes, ma'am.
2 acres.
2 acres, 14.5 guntas.
Now 2 acre, 14.5 guntas conversion is to be affirmed
Yes, ma'am.
eventually.
Yes, ma'am.
They have no grievance.
They have no grievance with respect of
Now what is left is only the
24 guntas.
So that 24 guntas is still pending before the suit.
Yes, my lord. Deputy Commissioner, it is pending. My only submission is that.
That 24 guntas
Yes, ma'am.
is still pending in the suit.
Yes, my lord. It is subject matter of the suit.
Correct. So you get an order of injunction, whatever in the suit.
My lord, my submission is that, my lord, larger question is required to be decided by the suit. And at that point of time, my lord, this particular fringe proceedings, my lord, my right, I will lose my right. And ultimately, my lord, this question has to be thrashed out by the civil court. And that particular proceeding is also pending. And now, my lord, the conversion, they did not participate before this honorable court. They did not participate before the AC, not before the deputy commissioner. And then, my lord, even before the division bench.
No, that is a concluded proceeding.
Yes, my lord.
So far as
Yes, my lord.
it's a concluded.
Yes, my lord.
Now we are only on the point of
Yes, my
this,
lord. The long silence of these particular persons, they did not get their name entered also. They did not bother to return the money also.
correct. You get some order before the civil court in your suit.
My lord, the proceedings are pending, my lord. I will pursue my remedy, my lord. Only thing is that, my lord, at this stage, my lord, it is in an arm twisting tactics. Either they should have participated before this honorable court in the resumption proceedings. They did not participate. They did not bother. Only after the passing of the order, after a great length of time, now they want to pursue their remedy without getting their name entered also.
No, let the DC hold his hand.
Yes, my lord. Yes, my lord. These are the question which has to be decided, my lord.
Anyhow, the suit is still pending
Yes,
with
ma'am.
respect to 24 guntas.
Yes, ma'am.
Let the DC hold
Yes,
his
ma'am.
hands, we'll see.
What will happen?
No,
He
no.
may develop this land. He may
No,
develop.
I will not develop the land, my lord.
No, that
I will, let me put on terms, my lord. I will not develop the land.
He may sell to some.
No, I will not sell the property also. The condition may be imposed on me also, my lord. That is because I definitely I have come before this honorable court to, till the decision is taken, my lord, let there be a condition on me also.
My lord, let it be subject to the result of the suit.
No, that I'll clarify. I'll clarify that. The Deputy Commissioner.
Or else next week, my lord, the matter itself can be disposed of.
It won't reach, we can't do that. Let us see. In 32991 of 25. AGA accepts notice for the first respondent. Caveat is put in appearance for the second respondent. Noticing that suits are still pending before the civil court, and in light of the contention raised that the KAT ought not to have remanded the matter back to an authority which has no jurisdiction, matter requires consideration. The Deputy Commissioner, proceedings before the Deputy Commissioner are stayed till the next date. Needless, full stop. Counsel for the petitioner submits that he would not create third-party rights in the interregnum.
Yes.
List along with serial number.
Serial number 14 and 15, my lord.
15.
Serial number 14 and 15, my lord.
14.
As well as writ petition number 33022 of 2025.
ಇದನ್ನ tag ಮಾಡ್ಬಿಡಿ. List along with 14 and 15. In 14 and 15, same order.
Yes.
AG accepts notice for first respondent.
Yes.
14 and 15. ಆಮೇಲೆ ಇದು ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ.
My lord, there is one more connected.
List along with WP number so and so. Yes.
13, Rajaram, yes.
I am for the petitioner, my lord. Kindly give 1 week time, my lord.
Each time granted.
Kindly give a date, my lord.
That request relist on.
25th,
Much sir.
14, 15, and then 16, serial number 16.
Yes.
Lords, I file an application, Lords, under Form 57, Lords, for regularization of unauthorized cultivation. Lords, this application, Lords, is filed, Lords, in December of 2018.
Yes.
Until now, Lords, it is not placed before the Hukum Committee.
Find out. AG accepts notice for the respondents. List the matter in the preliminary hearing list on.
26th.
Yes.
Lords, serial number 19, Lords, also similar. Your Lordship may pass the same order, 19.
Identical.
Same matter.
Same order.
Grateful.
17, Saraswati.
Very for petitioner. Writ of mandamus, my lord. The petitioner has filed an application for grant of Sagoli chit in his favor before the respondent number 2.
Regularization proceedings are already concluded.
No, my lord. They have not presented my application before the land grant committee itself, my lord.
They have not.
But they have granted for, in the same survey number, they have granted for some other 12 members, my lord. But my application is not been considered.
Though the relief is for the issuance of Sagoli chit, you find out the status. AG accepts notice for the respondent. AG to clarify as regards the application for regularization stated to have been filed by the petitioner. This is the matter in preliminary hearing list on.
First up.
Yes.
18.
In this also petitioner, my lord,
Same.
the same, my lord.
Same. Here also, they have not placed before the.
No, my lord.
Same one.
19 and 10, 20, Naveed Ahmed.
20 has to go before the Dharwad bench. The petition lords. Lords, the representation is given, Lords, sir, to the Chief Secretary, Lords.
What is the relief you are seeking?
Lords, Lords, in spite of an order of this court, Lords, to mutate khata in my name, Lords. Lords, Lords, there was a decree in my favor. Lord, the authorities, Lords, have kept the proceedings pending, Lords.
Correct. Now, if that is so, then your representation is to the Tahsildar.
Representation Tahsildar, AC and DC, we have given representation.
Correct.
All the three, Lords.
If it is if the Tahsildar is to affect the mutation.
Lord, that representation, Lords, is considered, Lords, this court, Lords, has directed the authorities to consider that representation, Lords.
Where is that?
Lords, kindly see, Lords, order.
Annexure E.
Annexure yes, Lords.
But that is a Dharwad bench.
Lords.
Now you make the Tahsildar as a party and you go there only.
Lords, we have given representation, Lords, to the principal secretary at Bangalore,
But
Lords.
it's okay. It's the Tahsildar who has to act. The previous writ is also Manjuna. You withdraw and refile. Noticing.
Lords, but it is the, Lords, can it, I pursue
You
this,
don't
Lords.
want to step on Dharwad's toes. Act.
Lord, the representation is given to the Lord Chief Secretary, Lords.
Correct. Earlier order is there. It's better because there the Tahsildar, etc. It will be better there. You file there. You make the Tahsildar as a party and file there.
May I
Noticing,
seek transfer, Lords?
file won't reach. Taking note of the previous order at Annexure E, it would be appropriate that the petitioner raises, files proceedings before the Dharwad bench. Accordingly, petition is disposed of. All original, without adjudication, all originals and certified copies to be returned to the petitioner after retaining Xerox copy of the same. Yes.
21, KM Prakash.
Please.
Appearing for the petitioner, your lordships.
Yes.
Raised for a week's time to comply the office objections.
By mistake, huh? It is, all objections are cleared.
Your lordships, a date may be fixed
What are
to
you
hear the
seeking?
matter. A challenge the orders passed by the respondent number 3, your lordships. Passed by the deputy
You
commissioner.
put it on some other day.
Yes, your lordships.
List in preliminary hearing list on.
20th.
Yes.
Grateful, your lordships.
Preliminary matters. 22, DP Mahesh.
Appeal petitioner.
Why is it come in preliminary hearing list?
Yes, we have.
Why is it come in?
A divergent finding. The learned assistant commissioner changed the entries in the name of the petitioner as per the registered sale deed. But whereas the deputy commissioner.
Here you had said your client is not keeping well.
Yes, yes, at ground. Now the entries based on the registered sale deed is set aside, my lord, subject to the result of the suit which is filed by the contesting respondents here.
Who appears for the respondents?
PD Surana. There is no sale deed in favor of the contesting respondent. In spite of it, my registered sale deed entries are cancelled. Their suit for injunction is pending for consideration against me.
Who went before the AC?
I have filed the appeal before the AC for change of entries as per the registered sale deed, my lord. My name is entered, directed to be entered. Thereafter,
Order of AC at page?
Page number. Yes.
Page number 22. Page 22, my lord.
It is in Kannada, Annexure B, page number 22.
Page 22.
As per the registered sale deed, my lord, the operative portion is at page number 24. 31, no?
Then what happened?
Then they have filed an appeal before the DC annexure A, my lord,
On what ground?
on the ground that they were not made as party to the appeal before the Assistant Commissioner. 22.
I felt with contesting respondent. Pray for 1 week and file is displaced.
We'll have it in the same stage next week.
Same. Same.
Relist the matter in the same stage on next week date.
25th.
20
Matter is pending.
25th.
With regard to section 11E sketch book, the matter is pending in Supreme Court. I am the first purchaser of the property. And because of 11E sketch, the registration is not.
Let us see. We'll see.
Yes, 25. 20?
Interim order.
Interim order making.
Interim order operation extended till the next day. But you have to place whatever that is not keeping well, because I'm taking it out of the.
Yes, ma'am. I'll place.
23.
I'm appearing for petitioner in this matter. My lord, the respondents were to get back.
There's an endorsement that's issued saying, my lord, there's a civil suit pending. Therefore, we're not able to. This passes on. Copy.
Is an order of injunction.
Yes, Lord.
Now you are seeking on the basis
Restoration of my name on the basis of the order passed by this honorable court. My lord,
you find out what is this, verify it.
Please.
Endorsement produced by AGA.
Endorsement is not served upon us, but nonetheless.
Placed on record. Placed on record. For the say of the petitioner, relist in same stage on. Yes.
First.
26th.
6th.
Please.
8th of December. 24. Bhaskar Goda N.
Milord, page 19, the schedule, Milord, the petitioner, Milord, he purchased 30 guttas of agricultural land is concerned. Revenue entries are mutated in the name of the petitioner is concerned. Milord, annexure E1 to E4 are the photographs which goes to show that these.
What is your prayer now?
Milord, my prayer, Milord, I've sought for quashing of annexure G. Milord, directing the Milord, the assistant commissioner directing the Tashildar to enter Milord as an unauthorized layout in column number 11 of the RTC is concerned. The order would be at page 31, annexure G. And on the last occasion, Milord,
There's a report sent by the office of the Tehsildar, report 2021, saying that there's an unauthorized layout form. The lordship goes to direct that the spot inspection will ascertain the status and thereafter proceed.
for a moment, annexure J. Annexure J, Milord.
No,
And annexure K.
Your instruction is it's unauthorized.
According to the report sent before 2021, now the petitioner's contention is that there is no development and therefore there cannot be a layout. Let there be a direction to conduct fresh spot inspection. Ascertain the status if there is actually any development to work and thereafter send a fresh report.
No, correct, but correct. Now the first time proceedings were initiated on what premise?
My lord, there was a report by the revenue inspector
That in agricultural land they're doing non-agricultural activity. Yes.
That report actually was not to in fact after the communication pursuant to the state petition, they were not to use the
The reason would be, please, my lord, survey number 13, it consists of.
No, we'll
vast-
set it aside. Liberty is reserved for them to take
Yes,
action.
yes,
if
yes, please.
circumstances are
Yes,
met.
my lord.
How is your file missing? Correct. How files go missing? The
Yelahanka property, my
we'll
lord, that
set-
is the reason
So
it
we'll
is.
set it aside, reserving liberty if circumstances are so made out to exercise power under law. I won't enter into the merits. The petitioner has sought for issuance of writ of certiorari to set aside the order dated 6/7/21 passed by the Assistant Commissioner at Annexure G. In terms of the direction of the Assistant Commissioner to the Tehsildar at Annexure G. The Assistant Commissioner has directed that entry be made in column 11 of the RTC that the layout is unauthorized and sales are prohibited. Petitioner has raised various contentions.
Your
AGA
lordship may
submits-
note annexure J have produced the encumbrance. It shows nil encumbrance. There are no transaction. From the date of my purchase, they have produced the encumbrance.
Petitioner has raised various contentions, including various contentions, and submits the order at Annexure G is without any basis. AGA submits that the petition may be allowed while reserving liberty to the respondents to take appropriate action as is permissible in law if circumstances are so made out. Taking note of the stand of the government, the writ petition is allowed. The order at Annexure G set aside. Consequently, the entries made in the RTC to be reversed. Full stop. Needless to state, as there is no adjudication of any issue on hand, the respondents are at liberty to take appropriate action as is permissible in law after following due procedure. All contentions are kept open.
Lord, time bound to reverse or forthwith, Lord, if I may request.
4 weeks.
Please.
Yes.
25. It's over.
All documents you have to scan, right? Both apart from all the grant registers, etc. Everything you have to scan so that tampering, everything would be avoided. Yes.
But serial number 25, your lordship may kindly grant me a week's time, my lord. I have to-
At request, relist the matter on.
Second.
Yes.
26. Natasha. Eighth. Eighth of this month.
Here for petition, it's just to consider my representation, my lord. That there be a direction, my lord, to consider my annexure A and B in, my lord. In accordance with law, it may be disposed of.
And one more contempt.
No, my lord. It may-
Wait, they're giving some endorsement, they're saying.
My lord,
So
the
I'll have it
represent-
next week. If they're going to give you an endorsement, you wait for next week. They're saying-
Even otherwise, my lord, I have to come back to challenge that endorsement.
that you
Instead, let them consider my, because there is also an application pending for allotment for the grant, my lord.
Correct. Let us see what stand they're going to take next week. If they're going to consider, well and good, there ends the matter. If they're not going to, at least to collect the endorsement so that you can challenge. Why you want to come back once again next week?
Because annexure B, my application is pending from the 79, my lord, which.
Let us see. Last chance. Huh? Last chance, you take a date and by then you take a decision. Relist in same stage on. Yes, on Monday.
Leelapi.
Your Lordship, I appear for petitioners. This is the matter wherein Your Lordship earlier occasion I have come before this honorable court. And direction is issued to them to fix the boundaries, conduct survey and fix the boundaries, my lord, which has not been complied. And subsequently, Your Lordship, there was a survey.
Yes.
The survey was conducted by the taluk sevak within the city. Now the survey has to be, report is to be ascertained. I believe it's with the north, that they're requesting for another week's time to look at the survey and do the survey after that, my lord.
Survey is done.
Survey is done in the year 2017, my lord. Copy was not furnished, I think, to the petitioner. They're aware of the survey, they admit to the
No, survey sketch I have
That has
produced.
to, that has to be concluded now.
Yes.
They're seeking in the prayer, my lord.
No, if you're going to give the report, we'll have it on the next day.
Order, my lord, implementation now.
No, correct. If you are going to give the order, we'll have it next, you furnish it in court.
Please, my lord, implementation will take some time. If the report has to be.
So when you tell us 2 weeks you want, we'll fix.
Now, all that I am seeking is with implementation of the earlier order. Pursuant to the order, Your Lordship, they have conducted survey. Even I produced that
Correct.
document.
So now they
but-
have to give the report.
Yes, Your Lordship, they'll have to do some consequential work, Your Lordship. There are other works which has to be done. Because once the survey is done, Your Lordship, they'll have to fix boundaries. They'll have to fix boundaries. They have to see that whether it is tallies.
So
with
shall
the-
we then dispose it up with a time frame?
Yeah, that can be done, my lord.
How much time? How much time? Find out.
Lords may fix about 2 months' time.
If he says correctly, others will pass over. Let you find out and you make a pass over.
My lord, 2 months is more than enough because this is only partial work is pending. That's the reason I'm.
Now make a mention, we'll take it.
Please, Your
Pass over.
28, Kalyan R.
For petitioner, my senior held up in another court, kindly pass over it, my lord.
These also matter in which they're seeking for making out revenue entries as per Sagwari sheet. Helping us to show an endorsement, my lord. I seek for another week's time.
When do you want?
Next week.
Relist in same stage on.
26th.
Yes.
Yes.
29, Akash VT.
Yes.
Land was granted to me. I have paid 350 rupees. Receipt is there. Saguli chit is there. And my entries in the RTC in the handwriting, it is there. Only it was not computerized. Then I made an application before the Assistant Commissioner. Assistant Commissioner allowing my application say direct the Tahsildar to inquire and make an entry. And the Tahsildar going out of the way sends the Revenue Inspector, get the spot inspection report, says I am not in possession. When if the title is with me, if I am not in possession, I will take possession. That is not the question before them.
Yes.
The endorsement says, worry ಮಾಡಿರುವುದು, I'll have to secure instruction on that.
A complete instruction, I'll have it next week. Relist the matter in the same stage on
Next week.
26th.
26th.
Very much.
Once the order of the AC is there, you have to comply with it.
30, Yashodhara Hegde. 30,
30, my lord, can I request for a pass over?
Petition in this case, my lordship.
Pass over. Pass over.
31,
Lords, for the petitioner, my lords. Seeking a direction, my lords, for to expedite the matter. As this honorable court in 2023 itself has observed that it has to be expedited, my lords. Till now, my lords, from 2023, it has been matter, but has been remanded to respond number 1. My instructions spoken to the ADC. Within 6 months, it will be. Let's go that. The said matter was remanded back to him in 2020. Now I have spoken to him, it is already 5 years old. To expedite the matter, it is because there are a lot of pendencies. So I think 6 months you have to consider this.
The present petition has been filed. seeking for issuance of writ of mandamus to expedite the proceedings in LRF within bracket 7A 41 BC /99-2000 pending before the additional deputy commissioner, Bangalore. Good stuff. AG upon instructions submits that efforts would be made to conclude the proceedings within a period of 6 months. In light of the same, the petition is disposed of, recording the stand of the government. Yes.
Grateful minutes.
32, Naveen.
Appearing for petitioner, my lords. My lords, here I am seeking for Podi and Durasti, my lords. My lords, initially I have given representation on 25/11/2024, my lords, with annexure G, page number 36, my lords.
Yes,
Thereafter, my lords, I have approached this honorable court, my lords, see page number 45, my lords, which has disposed on 24 June 2025, my lords, directing me to apply online, my lords. My lords, after that, what happened, my lords, in Mojani application, my lords, there is no option for applying for Podi and Durasti, my lords. Let's kindly come to page number 65. Where they have given notice to me, ತಿಳಿವಳಿಕೆ notice. Malats, here they have sought some documents to me, Malats, which is on 12/12/2024, Malats, which is not served on me, Malats. Recently, I got to know this. They have issued a notice, Malats. Malats, only I am seeking that. Let's let them give a fresh notice to me, and I will produce all the documents in accordance with law. They may conduct the Podi and Durasti proceedings, my lords. Because, my lords, it is a grant land, my lords. The land was granted, which is at annexure A, my lords, typed copy at page number 20.
So now we can dispose it of.
But my colleague is stepped outside. Could I request for a passover?
Passover. It will be disposed.
The petitioner's case has been referred to the missing company now, my lord. Pursuant to the first notice which the petitioner did not, certain documents were sought for from the petitioner because in our records we did not find the official memorandum as well as the Sakuri chief. Therefore, we referred it to the missing company now, my lord. May I please furnish the notice issued to the petitioner seeking for production of certain documents.
Yes, my lords. I have annexed it in page number 65.
Now his case is that the notice was not served on him, therefore this notice is dated 24, my lord. Since there were no production of documents and certain documents were not available with us, we have referred the case petition serial number 44 for reconstruction of documents, my lord, before the missing committee as of now, serial number 44.
So we can dispose it of.
Please, my lord, but my lord, as expeditiously, my lord, because fixing time.
So within a time frame, my lords, because
that we can't say, you will have to come back. In the
my lords,
event
because, my lords, in
No, they're
Devnalli, my
saying-
lords.
Correct, they're saying they have to, missing the records, they have to verify.
Yes, my lords, it is the, my lords, I am having all the certified copies with me and also original copies. I'll produce, let them give another notice, my lords. I'll produce all the documents which they are requesting, my lords, and let them proceed with that, my lords.
My lords may record that the notice issued in 24 seeking for the has been furnished.
Yes, yes, my lords. I myself, my lords, my prayer is, my lords, in prayer B, my lords, may I read. Issue a writ of mandamus directing respondent number 4 to issue a fresh notice to petitioner as earlier notice dated 12/12/2024 bearing number so and so has lapsed. My
6
lords.
months.
My lord, now, earlier there used to be a time set for reconstruction of documents, my lord. Now I believe the time, my lords may say expeditiously, will instruct.
My lords, they'll not do so, my lords. 1 year adru kodi so. Yado on time kodi.
1 year. In the event there's more time, then you seek for extension of AGA. The present petition has been filed seeking for issuance of writ of mandamus to respondent 4 to initiate and conduct 4D proceedings by taking note of the application of the petitioner at Annexure G. AGA submits that notice is now being served to the petitioner and on production of documents and verification on production of documents mentioned therein and on verification of original records, further proceedings would be taken. In light of the said stand, petition is disposed of. Respondents to endeavor to complete the 4D proceedings within 1 year. In the event further time is required, respondents to seek for extension of time before this court. Accordingly,
One
petition
more
is disposed
request.
of.
One more request, my lords. My lords, they are saying that they have sent to the committee for reconstruction, my lords. For that also direction may be issued, my lords. Because once it is done, 4D proceedings automatically will be conducted within the time frame.
If within 1 year nothing happens, you move it. I'm giving you liberty.
Yes, my lords. Yes. Much obliged.
33, Gurudat Priya.
For the petitioner, my lords. The writ seeking, my lords, enter the revenue entries, my lords, as per Annexure A, order of a DC. That, my lords, I gave a representation, my lords, is at Annexure F.
Instructions are that the order of the special DC is being challenged, but as of now, there's no challenge. The process of
I'll have it after 2 weeks, you find out. List after 2 weeks in same stage.
Vinayakas.
This order I've dictated, it will be uploaded. I've dictated. Petitions are dismissed.
In respect of my lord, I filed a wakalat for R5. It's not forthcoming in the cause list. My name may kindly be shown.
Yes.
My name has, your lordships have already ordered me, lord, that my name to be deleted for R5 and his name to be shown.
Office to show the name of learned counsel so and so for R5.
R5. I filed wakalat.
And office to
R4
show the
629.
name of learned counsel K. Anandram as representing R4 to 6.
R4 and 629.
R4 and R6 to 9.
6 to 9.
35.
For the petition.
Petitioner number.
Yes.
Petitioner number.
Notice to?
No, my lords, I appear for the only petitioner in 35.
Sorry, sir. Sorry, sir.
Let's respond.
You have to take steps, is it?
For respondent number 6, my lords, it is the address which is given by the respondent 6 by himself before the honorable, before the learned assistant commissioner as well as the deputy commissioner, and before this honorable court we have filed, please, my lords. That order we are seeking a review on the ground that, my lords, the petitioner is not made as a party to the proceedings, though the kata stood in his name to certain extent of the land.
Where is the order?
Lord, sir.
You are seeking review of which order?
Review of the order by this honorable court at page 43, please, my lords. This is a 2 acres of land.
No, correct. Then at least substituted service you'll have to take third time. Because the 2012 order.
Please.
So you complete the service, then we'll pass whatever orders to be passed.
I will, please, my lords.
Now this third time you have taken or not yet?
Third time we have not taken, my lords.
Week's time granted to take fresh steps.
Can I
So far as-
substituted steps, my lords?
After third time.
Third time.
For R6. Yes.
Obliged, please. My lords, may I seek one indulgence, my lords? My lords, it is my instructions that the person who has obtained this order is trying to probably alienate the land right now. No alienation with respect to the scheduled property may be ordered, please, my lords. Until then, it will not cause any prejudice to the respondents also.
2012 order. You file an application. I will, and move the matter, I'll take it up. You file an application.
Obliged.
Yes.
36 absent, 37. Ramesh, RM, 57.
T6.
2 weeks.
I'll serve the copy too.
37,
my lord.
Ramesh.
I am also appear before the 37.1 Danappa. That is writ petition number 5652 connected matter, my lord. The respondent received the endorsement stating that, my lord, the land is coming under the 18 kilometer, hence could not be granted to the grantees, my lord. It is the only question. Yes, within 18 kilometer, within 18 kilometer, but I have produced this Tahsildar order, it is 18.20 kilometer, my lord. It is not in the 18, no, 18.20, and also, my lord, the government is bound to grant the cultivators not to the other purpose. He has executed the land in favor of the Infosys. It is not permissible under the law. My lord, he has exchanged the land. It is not permissible under that government proceedings was, I have challenged this in the petition, my lord. They have exchanged the land along with Infosys, that it is not permissible under the law, my lord. No other purpose, the land was not used to other purpose. It is only grant to the land losers.
For industry also, that land grant can be made, and there is a provision for that also. And here, my lord, they have filed an application for Sajapura village, which comes within the aerial distance of about 4.5 to 15 kilometers, which is a restricted area up to 18 kilometers. Only one village in the Sajapur only will be excluded. So, I is farm 53 or 50 cannot be considered.
That is in which writ petition he has challenged?
5652 of 2020.
Where is that endorsement?
Endorsement is here, my lord, here.
Page on filed subsequent.
They have hand over the yesterday, my lord, this endorsement, my lord.
Could it?
ವಿಷಯ ಆನೇಕಲ್ ತಾಲೂಕ ಸರ್ಜಾಪುರ ಹೋಬಳಿ ಸರ್ಜಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 43ರಲ್ಲಿ 1 ಎಕರೆ ಗುಂಟೆ ರಲ್ಲಿ 6 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಅನಧಿಕೃತ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡಿರುವ ಭೂಮಿಯ ಮಂಜೂರಾತಿಗಾಗಿ
This you have to challenge.
Yes, my lord. I have also challenged, my lord. Another petition I have filed the.
No, that will say. In so far as 37.1 will dispose it off. It's for you to challenge this endorsement in accordance with law.
Moreover, my lord, the division bench judgment is there, my lord.
No, it's correct. In so far as this, you challenge it. If you have already challenged it, then that will be decided as per law. The other one.
Yes, yes, my lord. Yes, my lord. That liberty to. Yes.
37.1. GA. The present writ petition has been filed seeking for direction to the respondents to consider application in form 53 stated to have been filed seeking regularization of unauthorized construction. Full stop. EGA submits that claim was rejected as per an endorsement dated 18/3/22. This you have filed along with the memo.
Last occasion it was handed over. It is not in my file. There, you will get the Xerox.
You file a memo. You file it.
The council AGA submits that the application of the petitioner has been rejected.
of 2000.
On 18/3/22.
18.20, my lord. That is actually 18.20, my lord.
This endorsement is 18.
18, but here is 18.20, my lord. The same Tahsildar issued the 18.20 kilometer out of 18, my lord.
No, that will say. On
I have
18th
produced
of,
here.
18th of March 22.
Previously,
In light of the same, petition is disposed of, reserving liberty to the petitioner to take appropriate action if he is aggrieved by the endorsement dated 18/3/22. All contentions are kept open. 37.1 delinked from 37. And so far as 37, you take your stand.
37 also, my lord, it is coming under the same village, Sajapura village.
Same stand, my lord. Same
Same
stand. Same stand.
So that also will dispose. But where is the endorsement in 37?
Endorsement is also.
Kodi.
ಎರಡು ಇದೆಯಾ?
ಎರಡು ಒಂದರಲ್ಲಿ ಇದೆ.
ಎರಡು ಒಂದರಲ್ಲಿ ಇದೆಯಲ್ಲ? ಎರಡು ಒಂದರಲ್ಲಿ ಇದೆ ಸರ್. ಎರಡು ಒಂದ ಅದೇ ಸೇಮ್ ಎಂಡಾಸ್ಮೆಂಟ್ ಅಲ್ಲ. ಸೇಮ್ ಎಂಡಾಸ್ಮೆಂಟ್.
Here, my lord, the land is 373.
Survey number 373.
373?
That also 373, my lord, survey number. Same survey number.
Same endorsement.
Same endorsement.
Okay, you give a copy for this one.
Yes, sir. I will give.
The present petition has been filed seeking for a direction to consider Form 53 submitted by the petitioner's father for regularization of unauthorized construction. AGA submits that the application be rejected by an endorsement dated 18/3/22. Memo filed along with copy of endorsement. Right of the same petition is disposed of, reserving liberty to the petitioner to challenge the endorsement in accordance with law. All contentions are kept open. Yes.
They kindly have it next week, minutes. We'll comply with the objections.
List in B group on
8th of December.
I for early hearing is disposed of. List in B group on
8th of December.
Yes, next.
Deep
problem.
Lord, the copy I have served 2 more sets, Lord, now.
Now I will file a statement of objection within 2 weeks.
AGA submits. Copy has been received and statement of objection would be filed in 2 weeks. This is the matter in B group. 2 weeks ಆದ್ಮೇಲೆ.
9th of December. 40.
Interim order may be extended.
Interim order operations extended. Yes.
40.
I am appealing for 4 and 5. 1/24 and 2/24 which they have filed bringing LRs. That may be allowed.
They are filed along with Wakalat or?
I have filed Wakalat.
You have filed Wakalat. R6.
Yes.
The petitioner submits that R6 has died during the pendency of the proceedings. In light of the full stop, in light of the same, IA 1 of 24 has been filed.
IA 1 and 2.
Seeking for condonation of delay in filing application to bring LRs on record. IA 2 of 24 has been filed to set aside abatement, and 3 of 24 has been filed to bring the LRs on record. Third counsel, Sri Ganapati Bhatt has filed Wakalat for the proposed LRs and submits in view of the admitted facts, IAs are allowed. IAs may be allowed. Accordingly, IA 1 of 24 is allowed. Delay in filing application to bring LRs on record is condoned. IA 2 of 24 is allowed. Abatement is set aside. IA 3 of 24 is allowed. Proposed LRs are permitted to come on record and represent the interest of deceased respondent number 6. Necessary amendment to be carried out.
And my lord, short date may be given for because my lord.
Relist. What are the other?
Other defendants, my lord, that they have filed Wakalat.
Relist. Date for the week after next.
That amendment may be carried out within
9 days.
Petitioner to carry out amendment within 1 week. Relist on
9th of
Yes.
41.
An application to imply the Tahsildar and the committee, my lord, only for that, sir. They are the
AG.
necessary part is because is
IA.
and for amendment also, my lord.
IA 1 of 25 has been filed, seeking to implead Assistant Commissioner Tahsildar and Committee for Regularization of Unauthorized Occupation of Land. In light of the amendments made in the said application, application is allowed. AGA, who appears for the proposed impleading applicant, submits that application may be considered. Full stop. In light of the amendments made, application is allowed. IA 1 of 25 is allowed.
The next one is
AGA accepts notice for the newly added respondents. Full stop. Next, IA 2 of 25 has been filed, seeking for amendment of the petition to include additional grounds and prayers.
Additional prayer.
In light of the facts made out, IA 2 of 25 is allowed. Amended petition to be filed, incorporating the additional pleadings as well as taking note of the change in the cost title consequent to allowing IA 1 of 25.
May permitted to file amended writ petition.
Petitioner is permitted to file amended writ petition. Yes.
Vivekananda, 42.
The working from petitioner. Can you pass over?
Pass over.
43.
In this case, R3 is the government matter. By oversight, it has been stated, I have undertaken to file wakalat. I have undertaken to file wakalat on respondent number 8, not 3. Further, my lord, I have filed wakalat for respondent number 9, but it is shown as served, my lord. On 14th and 2024, I have filed the wakalat for
No,
9.
insofar as 9, your name is shown.
9.
Shown as served. 9 and 10 shown as served.
10 is served, 9 is
10
not.
is served and 9 is appearing, Your Lordship.
I have filed wakalat for 9.
Your name is shown there.
Yes.
Only for insofar as
3 is confirmed, it is government, but Lordship may direct the government.
R3, the Assistant Commissioner, AG is directed to accept notice for R3. Office to delete the name of Land Council Kalimullah Sharif shown as representing R3. Full stop. However, Office to show the name of Land Council Kalimullah Sharif as representing R9.
And I will undertake to file wakalat for 8 and 10.
Land Council Kalimullah Sharif undertakes to file wakalat for respondent number
8 and 10.
8 and
10.
Which is served.
Yes,
The
10
private
is
parties, Your Lordship.
served, my lord. 10
8
is
and 10.
Yes.
8 and 10. Yes, now
No, my lord, for
Your
filing objection to IA, Your Lordship grant me 2 weeks time, my lord. I will file objections and wakalat.
Your Lordship, they were trying to alienate the property, Your Lordship.
not
That's why I
alienating,
filed an IA.
We are not alienating.
Let them undertake, Your Lordship.
Third Council Kalimullah Sharif appearing for the respondents submits that they do not intend to alienate the property for the present.
Please, Your Lordship.
Pleadings to be completed within 2 weeks.
Please. Date may be fixed, Your Lordship.
2 weeks are
9th of December.
Please.
44. Keshav M.
Manoj,
44.
with respect to this matter, Manoj, IA for vacating stay, there's already a consent order that has been passed by this court on 22/11. So therefore, the IA does not survive for consideration. I have filed an application for amendment as well. That has the respondent, contesting respondent number 11 has not filed their objection. 22/11. 2024. Manoj.
Please,
Manoj, 22/11/2024.
light of the order dated 22/11/2024, consideration of IFI of 24 for the present is deferred. Now what is
IA for amendment,
Yes.
my lords?
Yes.
They have yet to file objections.
No, in fact, my lord, there is another IA. One IA, my lord, lordships have allowed. All that I'm asking is, I have been the owner, and my lord, he had
I
filed a
have
suit
not
against
received a
me in the
copy of
trial
that
court.
IA.
I'm not objecting adjournment, my lord. I'm just saying what the facts are. I understand, my lord, he has some family commitments to attend, so he's not ready with the matter. I quite understand. The issue is, my lord, that I'm only taking out my trees that are grown in my land. I have a sale deed. He had filed an injunction suit against me, which was pending before the trial court, which also, my lord, is in the interim order is denied. The injunction is denied and it is in my favor. So all that I'm asking is, my lord, cut the trees which was allowed in the earlier instance by this honorable court.
My lords, I have not received a copy of the IA that my learned friend is. So
No,
therefore, I
it is
only
only,
seek a
he is not
copy.
concerned. He is not, I am only asking the forest.
It's the subject matter of the entire list, my
He is
lords.
not
So
the owner.
therefore,
I don't have to
I am the,
permission
on
for it.
22/11/24 order is passed.
Yes.
Isn't it permitting?
Correct.
Permitting respondent 6 to evaluate and cut trees in custody.
Yes. Yes.
Hand over to R11.
Yes.
So what is the further order now? And then it says this order is subject to final outcome.
Yes.
So now what is the
What is
immediate
happening,
use?
Lord? They are not allowing me to take out the trees. They are not implementing the order and take the trees out from there, Lord. Just cut and keep there. That's it. Because the lordships will see that it may be valued by the forest department tomorrow, Lord. If the property is held to be his, then he can take the money equivalent of that.
Now,
The
who is
trees are
R6?
not being allowed to be taken out.
Who is R6?
R6, Lord, is
he's a range forest officer.
Yes.
So in terms of the order of 22/11/26, R6 is directed to evaluate
Yes.
the cut trees and hand over the same to
Yes.
R11. So you have to comply with that order. Who's R11? You represent R11.
Yes, he is R11.
No, who is R11?
No, I'm
Mr.
sorry.
Sridhar
I'm
Prabhu is
R11.
representing.
I'm R11. I'm the owner of that property. Lord.
Correct. Now you want a direction
Yes.
for implementation of this order.
Yes, my lord. He is not because the matter is sub judice. He is saying he is not implementing the order. Lordships, ಅದರಲ್ಲಿ clarification ಕೊಡುವಂತದ್ದು ಏನು ಇಲ್ಲ. Lordships may direct him to not hand over.
Notice the order of 22/11/24. Council appearing for R11 submits that despite the order of 22/11/24, said order not being implemented. R6 to ensure adherence to the order of 22/11/2024 within period of 2 weeks.
Yes.
Within a
And
period of
also
2
other
weeks.
trees also. There are
That
other
will-
trees also, my lord, in that property.
My lord, for that, he'll have to file a separate
ಅಲ್ಲ, ಇನ್ನೊಂದು
application. I
application
need
ಅಲ್ಲ,
to be
ಅಲ್ಲಿ trees ಅಂತ
objective.
ಹೇಳಿದ್ರೆ ಎಲ್ಲ trees
The
ಏ.
only reason, my lords, is
You file it, will pass orders. You file it, will pass orders.
Yes.
List week after next.
My lords,
Now
interim
this
order to
IFI
be-
of 24 I've deferred.
Sorry, my lord.
IFI of 24 I've deferred for the present. For vacating stay, I've
please.
deferred for the present. Yes.
That may be heard, my lord.
interim order to be extended.
Interim order in operation.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರಲ್ಲಿ ಏನು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ ಸಮ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಇಂಜಂಕ್ಷನ್ ಸೂಟೇ
My
ಡಿಸ್ಮಿಸ್
lords,
ಆಗಿದೆ.
now it's the subject matter of the writ.
It says modified in that order. There's some
It
observations.
is modified.
The interim order as modified for order dated 22/11/24 is extended till the next date.
45.
Grateful.
Take order BN 45. Let's move.
For the petitioner, my lord, steps to be taken in respect of the deceased respondent number 4, my lord. I seek 2 weeks.
2 weeks time granted to take steps as regards deceased 4 and fresh steps for issuance of notice to R6.
Please.
Yes.
46. Naveed Ahmed. 46.
At request made on behalf of AGA, relist the matter. Yes.
Second. 47. BR Vishnu.
Seeking of conversion in respect of only 2 guntas of land, my lord. It was rejected, holding that, my lord, the land attracts the provisions of PTCL Act. But, my lord, I don't intend to sell the property.
No, I passed an order last
Yes, my
time.
lord, accordingly, I am filing an affidavit saying that I don't transfer the property and I construct the building for my own. Copy. I'll copy you.
What is the endorsement now?
Lord, endorsement is at page 43J, my lord, annexure J.
What are the facts?
My lord, the land measuring 2 acres, 2 guntas, my lord, was allotted to the share of the petitioner in a partition of 2004. My lord, I had applied for conversion of the land for construction of the building thereon. My lord, on an earlier occasion, my lord, it was noted that, my lord, the land was under acquisition proceedings. Accordingly, there was no endorsement and that was rejected. I filed a writ petition before this honorable court, my lord. There was a direction passed by this honorable court as per page 38, my lord. Shall I?
Yes, yes. Then what happened?
Then subsequently, my lord, that endorsement was also there. Subsequently, once again, I approached the authority for conversion. My lord, I categorically stated that, my lord, I want this conversion for the purpose of construction of a residential building thereon. My lord, it was rejected based on a circular stating that, my lord, a sale permission will have to be taken for grant of conversion. That is annexure J, page 44, my lord. Only the columns are there, my lord. I say that it is not hit by PTCL Act. That was not an affidavit filed. A column was filled. The application itself is in the nature of an affidavit. ಅದರಲ್ಲಿ ತಪ್ಪು ಮಾಹಿತಿ ಅಂತ ನಾನು I am the owner since 4 decades.
If it is the owner, we can.
One problem is that, my lord, if I have to seek sale permission, my lord, I will have to give the name of a purchaser and I will have to show a land, alternative land for my use and all these things. Here, my lord, the situation is this, my lord, I want this for construction of my house. The land is also, my lord, only 2 guntas, even it's below 2,400 square feet, my lord.
Yes. The full bench decision of this court, my lord, says that once the land is converted, it loses the status of PTCL. So, my lord, this would be overcoming that by seeking conversion. Therefore, my lord, a sale permission would have to be granted. Only then conversion can be sought.
No, he does correct. He doesn't want to sell.
That, my lord, once this conversion is done, it loses the status of PTCL. So he may file an affidavit today.
He's filed an affidavit.
That, my lord, may not have great bearing today or tomorrow. Once a conversion order is given and it loses the status of a PTCL granted
But
land,
how can you compel him to?
then, my lord, he has authority to sell it.
He doesn't want to sell it.
My lord, that is today. That would be today.
So the further undertaking would be that in the event he intends to sell, he will. That's all what it can be. Now he wants it to be converted.
Should I, my lord, seek?
He wants it to be converted.
I seek instructions in this, my lord, and
Find
make my
out.
submission.
Find out. Now he wants it to be converted for self-use. So as of present, rightly so, that he does not intend to sell. Now once it's converted, as you rightly point out, by virtue of the order of the court, it comes outside the purview of PTCL land. Whatever undertaking you want to you can take. You find out what is to be done. Now suppose for the purpose of sale, let's assume you're giving permission. If you're going to impose some condition, I don't know what condition you impose. That condition he will comply. Though he cannot now identify seller because he doesn't want to sell. But equivalent to that condition, you say we will ask him to comply with that condition. While granting permission to sell, if you impose some condition, you have to pay something to the government or something like that, he will comply with it. There ends the matter. If he does not
conversion, these authorities again lose jurisdiction.
Correct. So now itself, you want him to do something which subsequent, which you would have done at impose some condition at time of sale. You ask him, we will ask him to comply with it. There ends the matter.
I'll verify below.
Monday, affidavit filed by the petitioner.
Copy be served.
To the effect that he intends to construct a building for his own dwelling purpose and has no intention to sell or alienate the same is taken on record. For AG request for short adjournment released on Monday in the same stage.
Two cases, writ petition 28651 and writ petition number 28426, my lord. My lord, in writ petition number 28651, your lordship has granted stay order, but not mentioned in the order, status quo order, my lord, but not mentioned in the order sheet, my lord.
Which matter?
28651, my lord. In Annexure A, the Deputy Commissioner has revised his own order dated 5/12/2024 to change the Kata in the name of the Kashi Vishweshwara temple in respect of the purchased land of the petitioner, my land.
Now in this you are saying that you had sought for an interim prayer.
Yes, my lord. First case, second case, second case.
What are the facts?
My lord, respondent number 52.
You take WPA.
This is Narsimaya claiming occupancy rights in respect of the.
No, you take WP 28651.
651, my lord. The petitioner is the purchaser of the land, my lord, during the pendency of the occupancy rights from the owner of the land, my lord, Krishnamurthy and his brothers, my lord. Originally, the land was granted to occupancy rights were granted to father of the Krishnamurthy, my lord. After his death, the Krishnamurthy and his brothers filed an application and granted occupancy rights in respect of the Sitaram Shastri of the children, my lord. They have sold the property to the petitioner and through registered sale deed, my lord. The Deputy Commissioner, while passing an order, held that the purchase of the sale deed during the pendency of the case is illegal and void, and Krishnamurthy has no right to sell the property to the petitioner, my lord. Again, they have passed an order on 5/12/2024. Again, on 25.
Annexure?
My lord, at Annexure A, my lord. At Annexure A. In 28426 at Annexure A, my lord. Page number 26, my lord. 26 in operation of the order 46, my lord.
You are referring to which page? Page number in which writ?
In 28426 is the first order, my lord, 5/12/2024.
Page?
Page number 26, my lord. 26 to 46, my lord.
So the Deputy Commissioner has
passed an order, rejected the occupancy rights of the deceased Narsimaya, who is the petitioner, who is the other petitioner, my lord.
Then what happened?
Then I am the purchaser of the property, my lord. The Padmama is the purchaser of the property from the landowners of the Krishnamurti, my lord.
No, but now his occupancy rights have been rejected.
Has been rejected by disease Narasimha, my lord, who is claimed the occupancy rights in respect of the land.
No, now you have purchased from Narasimha.
From no, my lord. I am purchased from the Krishnamurti, my lord. His father was in possession of the land as the Archaka of the Kashi Vishwesvaraya temple. After his death, Krishnamurti and his brothers filed an application before the land tribunal, who granted the occupancy rights, my lord.
Where is that?
In page number annexure F, my lord, page number 94, my lord. 94 to 96, 46, my lord.
Next. Annexure EL, that is the orders of the Assistant Commissioner.
Page number.
Deputy Commissioner.
Page 100, my lord.
Page number 57 and 58.
Just wait.
Please explain.
Just wait.
Allah.
In page 100, in 100, my lord.
Page number 58, why their application has been rejected and that.
Just wait.
Just give an explanation.
Now, in terms of annexure F,
yes, my lord.
Occupancy rights were granted.
Was granted to Krishnamurti, Ranganatha Sastri, and Kashi Vishwesvaraya, were the children of Sitaram Sastri, my lord.
Jointly in the name of all the three.
Oh, yes, my lord.
No.
In the year 1975, my lord. That order has not been considered by the Deputy Commissioner passing an order, my lord.
Now, this occupancy rights were granted in survey number 8.
Yes, my lord. Survey number 8, measuring 4 acre, 13 guntas, and the same has been purchased by the petitioner, my lord, through the Easter sale deed, my lord.
Sale deed executed on?
Executed on 5/8/2006, my lord. Page number 133, my lord, at annexure G.
5/8/2006,
my lord.
Under the Land Reforms Act, bar is not to sell for how many years?
15.
15 years, my lord. 15 years, my lord.
Sale deed at annexure?
Annexure G, my lord. 5/8/2006, my lord. Page number 133, my lord.
Now the DC has passed an order
on 5/12/2024, my lord. At annexure A, my lord. At annexure A, page number 26, my lord.
What is the operative portion?
Operative portion, my lord. Page 46, my lord. The inam of the petition number 1A to F, legal as a petition number 1 of Narasimhaya for occupancy rates in respect of the land bearing survey number 8, measuring 2 acres, 6 guntas, Nethanalli Gram Panchayat, Kasubapalli, Magadi is hereby rejected. The case is dismissed against the petition number 2, M.R. Krishnamurti, my lord.
Now, why did Krishnamurti again file another application in 24?
During the penny, after the death of Narasimha Sastri, his father, he filed an application for grant of occupancy rights, my lord. His father was in possession of the property, was possession of the land since more than 20 years, and temporarily tenancy grant was granted to Narasimha Sastri, my lord.
Now, this sale deed was executed by?
5/8/2006, Krishnamurti, my lord. Krishnamurti and his brothers, my lord.
Now, the second appellant in annexure A,
yes, my lord.
Second petitioner at annexure A, is the same Krishnamurti has sold to you?
Yes, my lord. Krishnamurti and his brothers, my lord, sold to the petitioner Padmama, my lord.
But why did they file Form 7A? This is
Form 1975, my lord.
No, once again they filed.
Yes, my lord. Annexure F, my lord. After the death of his father, his children has filed an application, my lord.
You appear for?
I'm appearing for respondent number 4A to D and 4 to 6, my lord. My lord may be taken page 58, my lord. Page 58, why the DC has dismissed the application of the.
You appear
petition.
for?
I am appearing for respondent number, that is, I also filed application. My father has also filed application for grant of occupancy rights in respect of first petition.
Narasimhaya, my lord.
Annexure F,
Please.
already land was granted.
No, my lord, ಅದನ್ನೇ explain ಮಾಡಿದ್ದಾರೆ. ಯಾಕೆ explain ಮಾಡಿದ್ದಾರೆ? Why the application has been dismissed? The DC has explained in page number 58, my lord. 57 and 58.
This is the appeal. Annexure?
Annexure E, my lord. Annexure E, page
Which
number
writ-
53.
Which writ
In
petition?
petition number 28651.
You are referring to which order?
DC, sir. 5/12/2024. Annexure E.
No, he is referring to the other writ petition.
ಅವರು ಅದನ್ನ ರೆಫರ್ ಮಾಡ್ತಾರೆ, ಅದಕ್ಕೆ ನಾನು ಅವ್ರ ಪಿಟಿಷನ್ ಎಲ್ಲ ರೆಫರ್ ಮಾಡ್ತಾರೆ.
Our petition, writ petition 13-214.
Which page? Yes,
Annexure
which
E,
which
page number 53.
Which page?
Page number 57, madam. 57 in the internal page 5, DC side. Page number 57 of writ petition. Nanu kottru.
Yes.
Please, the down. The DC Bangalore had passed the orders in case number 10/8/2000 as follows. ಮೇಲೆ ವಿವರಿಸಿರುವಂತೆ ಮಾಗಡಿ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ನ್ಯಾತೇನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 8 ಜಮೀನಿಗೆ
No, 10/8/2001.
Please.
But this order in the land reforms was passed.
No, my lord, that is only tenancy has been granted with respect to cultivation of the land, that's all. Ownership has not been granted. That is why it has been dismissed. Ownership has not been granted.
How can ownership be granted? For he is filed, asked only for occupancy rights at
Yes,
election.
madam. Ownership cannot be
Asked
granted.
only for tenancy rights that has been granted in LRF 830 of 75/76.
My lord, ಅದನ್ನೇ ಆರ್ಡರ್ ಬಗ್ಗೆನೇ ಬರೆದಿದ್ದಾರೆ. ಆ ಆರ್ಡರ್ ಬಗ್ಗೆನೇ ಬರೆದಿದ್ದಾರೆ.
But the
ಎರಡನೇ
date-
ಅರ್ಜಿದಾರರು ಪರಿಗಣಿಸಿ ತೀರ್ಪು ನೀಡಲು ನ್ಯಾಯಯುತವಾಗಿ.
The date itself is wrong.
ಹೌದು, ನ್ಯಾಯಯುತವಾಗಿರುತ್ತೆ.
The date is wrong. It's not 10/8/2001. It's in 1970.
75, madam.
75.
ಅಲ್ಲಿ ನರಸಿಂಹಯ್ಯ ಅವರು ಮಾಡಿರ್ತಕ್ಕಂಥ ಸೇಲ್ಡ್ ಯಾಕೆ ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ. ಎರಡನೇ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಿ ತೀರ್ಪು ನೀಡಲು ನ್ಯಾಯಯುತವಾಗಿರುತ್ತದೆ. ಇನಾಮ್ ಡಿಸಿ ಅವರ ಆದೇಶದಲ್ಲಿ ವಿವರಿಸಿರುವಂತೆ ರಂಗನಾಥ್ ಶಾಸ್ತ್ರಿ ಇನಾಮ್ ರದ್ದಿಯಾಯಿತಿ ಕಾಯ್ದೆ ಕಲಂ 48A ಪ್ರಕಾರ 38A ಪ್ರಕಾರ 34A ಪ್ರಕಾರ ಗೇಣಿದಾರರಾಗಿ ಮುಂದುವರಿಸಲು ಮಾತ್ರ ಆದೇಶ ನೀಡಿರುತ್ತದೆ. ನಂತರ ರಂಗನಾಥ್ ಶಾಸ್ತ್ರಿ ಅವರ MR ಕೃಷ್ಣಮೂರ್ತಿ ಅವರ ಅಧಿಭೋಗದಾರಿಕೆ ಹಕ್ಕು ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ನರಸಿಂಹಯ್ಯರವರು ಹಾಜರುಪಡಿಸುವ ಪಹಣಿ ದಾಖಲೆಗಳಂತೆ ರಂಗನಾಥ್ ಶಾಸ್ತ್ರಿ ಅವರ ಜೊತೆಯಲ್ಲಿ ನರಸಿಂಹಯ್ಯವರ ಹೆಸರು ದಾಖಲಾಗಿದ್ದು ಸಾಗುವಳಿದಾರರಾಗಿರುತ್ತಾರೆ. ದಟ್ ಇಸ್ ವೈ ಇಸ್ ಫೈಲ್ಡ್ ಒನ್ಸ್ ಅಗೇನ್ ಅಪ್ಲಿಕೇಶನ್. ಈ ಕಾರಣಗಳಿಂದಾಗಿ ನೇತನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 8 2 ಎಕರೆ 6 ಗುಂಟೆ ಜಮೀನಿಗೆ ನರಸಿಂಹಯ್ಯರು ಮೈಸೂರು ಧಾರ್ಮಿಕ ದತ್ತ ಇನಾಮತಿ ರದ್ದಿಯಾಯಿತಿ ಕಾಯ್ದೆ 1955 ಅಡಿ ಅಧಿಭೋಗ ನೋಂದಾಯಿಸಿದೆ. ಮಂಜೂರುದಾರ ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ಟಬೇಕಾದ ಪ್ರೀಮಿಯಂ ಹಣ ಪಾವತಿಸಲು ಆದೇಶಿಸಿದೆ. ಬಟ್ ದಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿ ಪಿಟಿಷನರ್ ಇಸ್.
Let us see, it requires consideration.
Please.
Next, learned counsel for the petitioner submits that by virtue of the order of the DC, the proceedings before the land tribunal in LRF within bracket KA 830/1975/76, whereby rights were granted in survey number 8 to an extent of 4 acre 13 guntas has been nullified, which has the effect of prejudicing the petitioner's rights under the sale deed dated 5/8/2006. Full stop. Noticing that the petitioner is not arrayed as a party in the proceedings before the deputy commissioner, there would be stay of the order in LRF INM 01/2007-08. Now, in which matters you are appearing?
First matter, 48.
You appear for?
I am appearing for petitioner.
Respondent number?
Petitioner. First matter.
First matter is his
First matter,
matter.
second matter.
Second matter.
Second matter is appearing.
Correct. In first matter, you will undertake to appear.
Please.
Cost title towards. In 28426, you appear for which party? Name?
4A to 4D, my lord.
Or Torsi.
Sir,
28651 only I am appearing for.
Just 1 minute. You take the cost title of 28426. You appear for
4A to D.
4A to D, my lord.
4A to D.
so and so. Undertakes
No, my lord. 4A to D, 5 and 5A to C and 6. For all.
council so and so undertakes to appear for respondents 4A to
D.
4A to D.
D
And
5A to C, my
5A to C and 6.
5A to C
and 6, my lord.
and 6.
In WP 28426, my lord.
Yes, sir. Right, next.
In WP,
Yes, just wait.
yes.
13226. Sir.
That is, I am appearing for petitioner.
In 13226, you have to take steps.
Please, R6.
Land Council for the petitioner submits necessary steps will be taken as regards deceased R6.
Interim order.
What is interim? You have also sought for stay of DC's order.
Not to cut the.
Not to cut and remove tree and there is an
Standing
interim order, my lord. Not to cut trees, my lord.
So that interim order will extend.
Yes, my lord.
The interim order granted in 13226 of 25 is extended. It's there and there's no, it's not limited. Angi there. Next. Then in 28651.
651, my lord.
You appear for
Same.
Petitioner, my lord.
same.
Same.
4A to, sorry, 4A to D.
4A
to D.
Just one. And council so and so undertakes to appear for respondents 4A to D, 5A to C and 6. List in B group after service is complete. Yes.
My lord, status quo, my lord.
I've stated the order of the DC.
Yes, my lord. Yes. Grateful, my lord.
Adu insofar as petitioner is concerned.
Hello.
Or what's the interim order?
Status quo may be granted.
Huh?
Status quo may be granted. Not to stay the.
Let us see now. Only insofar as him.
No, my lord. No, my lord. During the pendency of the
That
case.
will decide.
During the pendency of the case, the sale deed has been executed.
Correct.
That is why the orders passed by the.
Okay, let's see. You file your objection.
Yeah, status quo may be granted. Status quo may be granted.
Status quo as on date.
Please, as on
Yes,
date.
my lord. Status quo as in respect of the two orders of the DC, my lord.
Only one order is there.
Two order is there, my lord.
Subsequently, that RTC has been transferred in the name of Vishweshwaraya Temple.
Subsequently, they review his own order by DC, my lord.
Correct. So what is your interim relief now? What is
My lord.
What is the interim relief you want?
Interim relation to stay the change of kata, my lord. If the change of kata is.
Will say status quo regarding revenue entries.
Yes, my lord. Yes, my lord.
Stay, badlo. There would be an order of status quo regarding revenue entries as on date.
Yes, my lord.
Yes.
49.
Check.
Yeah, for the petitioner, Lord, 49.
49.
Yes.
Serial number 49, I appear for the petitioner, Lord.
Take my stand in writing, Lord, for the status quo.
The AGA submits that they would take the stand in writing. Statement of objections to be filed within 2 weeks. Interim order earlier granted is extended.
50.
Great.
For the respondents, Lord.
For petitioner in this, impleading applications have been filed in both the petitions by the common impleading applicants.
I have filed an application and also an application seeking vacation.
Lord, there is some urgency in the matter, Lord. The
I'll
land
have to
survey
file-
number 18, Lord, is a Gomad land, Lord. In that land, Lord, Deputy Commissioner, as per annexure R1, Lord, Deputy Commissioner granted 2 acres 20 guntas in favor of Jilla Panchayat.
Page 19, please, ma'am. First page.
No, in which matter you are referring to the page numbers?
First matter, please, my lord, 23830. Please.
Which matter you are referring page numbers? Mahesh, in which matter you are referring to the page
My lord,
numbers?
in 23830 only, I have filed application for vacating interim order.
Now, what are the facts?
Lord, the land bearing survey number 18, Lord, is a Gomad land. In that land, Lord, 2 acres 20 guntas was granted by Deputy Commissioner to the Jilla Panchayat, Lord, for the construction of solid waste management unit, Lord, in respect of 3 Gram Panchayats, Lord, that is Kadabagere, Kachuhalli, Machwalli, Kodigehalli. After the said grant, Mulad, Jilla Panchayat Mulad has handed over the land to the Gram Panchayat. And Gram Panchayat in turn, Mulad, a tender notification was called and tender was allotted to a private person for construction of the unit. In the meantime, Mulad, this petitioner claims to be the legal representative of one of the grantee. They claim that Mulad, in this survey number 18, some portion was granted to one Vairappa blood, and they are the LRs of that person granting. They claim that this is a Inam land, and during computerization, in respect of this survey number 80, name of government as Gomad land is wrongly shown. This is their claim. It's a disputed question of fact. After the tender was awarded, work was started. During that at that time, he came to this spot, puts a board saying that he has already filed a writ petition, that is WP 12179 of 2025. In para 11 of my application, I have stated. Para 11 of my application for vacating, I have stated. He files a writ petition and puts a board on the spot saying that a writ petition is filed and a civil suit is also filed, not to do anything in the spot. That is the board he puts. There was no interim order at all. After coming to know that this Gram Panchayat filed an application for repleading in the said writ petition, he did not move the matter at all after receiving the copy. He files this writ petition, second writ petition, and obtains an interim order to maintain status quo. On this basis, Mulad, now work is stopped. I have produced Mulad photographs R5 to R8 to show that work was in progress before granting the interim order. This is abuse of process of the court, Mulad, virtually. Civil suit is also there, Mulad, according to him.
Yes, government.
We'll have to get instructions.
Public interest is affected, Mulad, because of this.
Correct. Let the government complete their instructions. I'll grant a short
meantime, Mulad, work has now, Mulad, matter has reached Lokayukta also. Complaint is filed against Gram Panchayat. It is disputes are multiplying, Mulad. Unnecessarily, PDO is facing difficulty before Lokayukta. Lokayukta.
You're worried about Lokayukta or solid waste management?
Solid waste management, Mulad, it's a public interest, Mulad.
Okay, no, we'll see.
Human problem.
Now your application, what has happened? Your application for
My application, I am the grantee in 1960, please, Mulad. My name has been in the RTC, handwriting RTC. When in the computer, it has been retained only in the column number 12, please, Mulad. Taking advantage of that, this piece of land, this 2 acres, 20 guntas of land, is been granted in 23830 also, and also in the other writ petition, please, Mulad, which is connected with this matter 350352. Your lordships could see the if your lordships would kindly take to the impleading applications.
No, government, you'll have to take a stand, please. Whether it
Mulad, it's a disputed question, Mulad. He has already approached civil court.
I have approached this matter, please, Mulad. It was in 350352 place, without knowing that this land was allotted. When the slum board has appeared there and they have filed the writ petition, please, we had the allotting of this land has come to our knowledge, and I have mentioned in my writ petition that I have filed. And after coming to knowledge that this land has been allotted to slum board, I have filed this writ petition. I have not suppressed anything before this honorable court.
What is that other writ petition that you have?
It is also same cause, but the allottee there is slum board, please, Madam. In one matter, the allottee is the Jilla Panchayat, where they have to establish the solid waste management.
What is that writ petition number?
It has been connected today itself. 35052, please, my lord.
No, no, he was mentioning one more writ petition number.
Please, my lord, that was earlier writ petition for Mike.
That you have withdrawn.
That I have withdrawn. I have mentioned it.
Withdrawn, Lord, after obtaining interim order, he withdrew, sir. When I filed an application
That was
for
only
vacating,
that was only for
withdrew
Mike
that
entry.
The government, you complete
You
your.
have filed including application.
Lord, may I request, Lord, one thing? I may be permitted to.
Board, my lords. In pursuance, my lords, of the order of the Deputy Commissioner, my lord, the Slum Development Board, my lords, has to forum sites, my lord, and allot, my lords, in favor of the beneficiary. That by virtue of the interim order of stay, my lords, the entire process has been started.
These implementing applications, they have. Please, my lord.
AGA to complete instruction in light of urgency pleaded by counsel for the other respondents. Relist the matter on. Read it.
Short date may be given, Lord. Otherwise, we may be permitted to proceed with the.
Lord, 27th, please, my
Set of writ petition.
26th.
27th or 24th.
26th.
25th itself, please, my lord. 27th, please, my lord.
25th.
25th.
25th in the same stage. Please. Now, government, you will have to take your stand. Please.
Interim orders mechanic.
Interim orders in operation extended to the next day. What is the total extent in survey number?
My lord, in the survey number, it is around 200 acres, 253 acres, please, my lord.
But how do you say this land only there?
Please, my lord, I have been in possession from right from.
Correct, but how do you say that?
Please, my lord, if your lordships could take the impleading applications filed by the same impleading applicants in both the petitions, they have produced the sketch, please, my lord. They identify the same piece of land for the Jilla Panchayat as well as for the slum board.
How do you say that your land is the?
My lord, I am in possession. I have produced the photographs.
Right,
All these years, the land has not been ported. The grant is
It's a question of fact, Lord.
So, under the Village Officers Abolition Act, I have been granted with the occupancy rights. Right from 1960, with the all the RTCs are standing in my name, and I have been cultivating that 9 acres from more than 7 to 8 decades, please, my lord. When the standing crops are there, on the pretext of that, this portion of land has been allotted in that 9 acres. They are precipitating the matter for by putting up the constructions and. Please, my lord.
Government, you'll have to find out how you're going to identify.
Please,
yes.
Obliged.
Could that be recorded, my lord? Could that be recorded?
The government advocate to take a stand in writing and address the contention raised by the petitioners that land has not been, that no PODI proceedings have taken place, and petitioners are in possession of land which is now sought to be reserved for public purpose. AGA to specifically advert as to the identity of the land that is now reserved and sought to be allotted for the other respondents and its location vis-a-vis the land in possession of the petitioner.
In fact, in our impugned order itself, they identify that we are in possession.
Let us see. Yes.
Obliged.
I've received the objections just now, my lords. Just now. Anytime next week.
Can we file this in the office or give it here? This matter is actually there's an interim order operating against the
statement of objections filed on behalf of respondent number
5. 5 has served to me.
5 is served now.
Respondent number 1 also.
One also is served.
Also is
5 and 1.
1.
Kindly have it on Friday, Mira.
No. Now you are filing it in the counter.
It's ready.
So could it? Respondent number 5 and 1 is taken on record. Relist on.
Friday it may be because next week is some inconvenience for me.
Friday I can't. I'm doing Thursday and Friday special bench matters.
Friday there'll be a lot of special.
Monday it may be.
Note good. Date good.
First of December.
First.
Interim order needs to be.
Interim order in operation is extended to the
First would be quite long, my lord.
Let us
have
see.
it next week, my lord.
We'll hear it. Let us see. Yes.
My lord,
Yes.
I have filed a LR application on 1/9/2025.
It is served on the respondent proposed.
Yes, my lord.
It is served.
Yes, my lord, served.
R9. Notice over there. Notice has gone or still to go?
Still to go, my lord.
So notice must go on the IAS. As it is stated that R9 has died. IA 1 of 25, IA 2 of 25 and 3 of 25 have been filed to bring LRs of R9 on record. Issue notice on the said IAS.
53.
IA 2 of 22. Bidder.
53. Sumitra.
For the petitioner, IA sought for substituted service of notice to respondent number 5 by advertisement of.
You have taken notice previously.
Yes, my lord. 2 times we have taken, my lord. After filing NOC, Wakalat also we have.
Once more you take, next time we'll order.
He is in the same address, Your Honor. Deliberately, he is
Let us
avoiding
see.
the service
You
of.
take 3 times, then we'll pass orders.
Before filing our NOC Wakalat also, the previous council has taken.
So totally 3 times you have taken.
Yes, yeah.
IA 1 of 25 has been filed. Seeking for taking steps for service of notice through paper publication as regards R5. Taking note of the amendments made in the application. Application is allowed. Petitioners permitted to take out notice to R5 by publication in Kannada newspaper, Kannada Prabha.
Yes, ma'am.
Which edition? On or before
Bangalore edition.
3rd of, showing the date of hearing as Kannada Prabha Bangalore edition.
Bangalore edition.
You write it there.
Yes.
Accordingly, IA is allowed. You write it Bangalore edition.
54 and 55. Ramesh Kumar.
Yes.
I paper petition. The land has been granted in the 1949, where the proceedings are pending before the Assistant Commissioner for Restoration of the land, where now the land is allotted to the respondent 4, 3 and 4.
Proceedings are pending
before the Assistant Commissioner for Restoration of the land.
PTCL.
PTCL.
You are?
I am the grantee's legal representative.
Now what has happened?
Well, now the land is allotted to in favor of the respondent number 3 and 4. Where in the last occasion where the Honorable Court yet to grant the interim order. Now that for last 2 weeks they are interfering with my position and putting the compound wall. And now
okay, let us see. AGA to file the statement of objections within 10 days. Relist the matter in the same stage on
9th of December.
Not to only I had filed an application where interfering with my position and putting the damaging my compound wall.
No, let us see. Let them file, then we'll consider.
Till then, not to precipitate them. Day in and day out, they are respecting by the respondent 3 and 4.
Just wait. Let them take the stand in writing. We'll pass some order.
Any date may be fixed next week.
Date could be
9th of December. 56. Murthy K.
Lords, I represent the 7th respondent, Lords. Last occasion, I received the copy of the impleading application. A request for 10 days, Lords. I'll file my formal objections.
It's only impleading, my lords. The 7th respondent sold the property in question to proposed respondent number 8.
They've given the title deeds and I just have to verify, Lords, and get
It's a
instructions.
tenanted land, my lord. It was granted again after remand without conducting inquiry. It is held in favor of respondent number 7.
no, on the main. Get ready on the main now.
Yes. In fact, when the curfew was declared, when annexure A, my lord, dated 17/3/2022 was declared as holiday on that day. On that day, curfew was there. On that day, the tribunal passed the impugned order on annexure A.
How do you say that?
I have produced annexure, my lord, in this regard at annexure K.
Annexure?
Annexure L, page number 110, my lord. Deputy Commissioner Chikbalapura declared as curfew from 15/3/2022, 17/3/2022. Impugned order passed on 17/3/2022, my lord. Last, ಕೆಳಗಡೆ ಪ್ರಸ್ತಾವನೆ ಪರಿಷ್ಕೃತ ಆದೇಶ ಲಾಸ್ಟ್ ಇದೆ. ಸಲುವಾಗಿ ಮುಂಜಾಗ್ರತಾ ಕ್ರಮವಾಗಿ ಸಾರ್ವಜನಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾದ್ಯಂತ 15/3/2022 ಮುಂಜಾನೆ 6 ಗಂಟೆಯಿಂದ ದಿನಾಂಕ 17/3/2022 ಮಧ್ಯರಾತ್ರಿ 12ರವರೆಗೂ ನಿಷೇಧಾಜ್ಞೆ ಜಾರಿಗೊಳಿಸಿ so and so. Has to be go back.
It was set down for your arguments or what?
No, actually it was reserved for our orders from 2021 onwards, my lord. It has to go back, my lord. Earlier, the land tribunal held in my favor and passed orders. Accordingly, the grant certificate issued, mutation effected, and thereafterwards, the seventh respondent claims to be the family member of the landowner, filed objection, filed writ petition before this honorable court in 2007, my lord. In the writ petition, my lord, grant cancelled, set aside and remanded to the tribunal. The tribunal kept pending the matter from 2010 to 2022. No inquiry has been conducted.
No inquiry.
No inquiry has been conducted. No documents are produced by the seventh respondent to prove that is related to the family or the land.
Now, have you produced the order sheet?
Of the Deputy Commissioner, my lord?
Yes, of the land tribunal. You are saying that there were no proceedings, isn't it?
Yes, my lord, it is.
Government, you verify. If it is so that there was no inquiry consequent to remand, then it has to go back. AGA, let us see.
Yes.
You are saying there was no inquiry.
Yes, my lord.
So what was the remand order?
Remand order is at my lord.
Page?
Yes. My lord, page number 95, annexure H, my lord.
Lord Counsel for the petitioner submits that consequent to the order passed in WP 13124 of 1997, matter was remanded to the tribunal and liberty was reserved to both parties to lead additional evidence / documents. Full stop. It is submitted that further direction was issued to the tribunal to hear the parties. Counsel for the petitioner submits that consequent to the order of remand in the petition referred to above, there was no inquiry conducted.
Yes, my lord.
And order passed at annexure A is without adhering to principles of natural justice.
And there was a curfew on that day.
AGA to secure instructions and records, relist in preliminary hearing list, only on that point, on 1st of December.
Interim order may be extended. Already it is in force with respect to possession.
And that I have not limited it. I have not limited it.
57.
7, I prepare respondent number 4 and 5.
My lord,
2 weeks time to
it is a case, my lord.
Statement of objection, my lord.
You appear for
Appear for respondent number 4 and 5, my lord.
purchaser.
Purchasers, my lord.
This is a grantee's writ petition.
My lord, the petition filed by the legal heirs of grantee, my lord. My lord, the land granted in their 1974 and grant certificate issued in their 1985 as per annexure C, page 33, my lord.
What is the interim order you are seeking?
My lord, now the stay of the impugned order annexure A, my lord.
No, we have to hear the matter. No, purchasers,
Only on the ground that the deputy commissioner passed an order, allowed the appeal filed by the purchaser on the ground of that is a delay of 7 years, my lord. I relied upon the judgment of
Application
the
for restoration is dismissed, my lord. Therefore, stay not necessary.
assistant commissioner for the first round. He restored the land in favor of the legal heirs.
with a condition for 25 years of non-alienation period. Agreed by the order, the purchaser challenged the same before Deputy Commissioner.
Let us see.
My lord, land is in question, my lord, and payment of absurd price, my lord.
We'll hear the matter.
Please,
Right,
for 2 weeks time, my lord, I will file objection.
the grant certificate I produced annexure C, my lord. It is a muppattu. It is a free of cost, my lord.
No, correct. Now government, you get the records. Relist the matter in B group on date code.
First week of, it's the 8th of December.
8th. You file a synopsis.
Yes.
Both
And my
sides
lord, I
to-
relied on the judgment of this honorable court coordinate bench, my lord. There is no delay of within 7 years. And also in the judgment of the honorable Supreme Court Satyan case, my lord, even 8 years is not the delay and latches, my lord.
Consider both sides.
And it is purely granted for.
Sale deed of the year 2005, the non-alienation 15 years over, my lord. Therefore, in the sale deed, they specifically mentioned, my lord, the prior permission was taken, my lord. Therefore, I will file detailed objection.
Prior permission was taken.
Taken in
No, my lord.
the sale deed, they clearly
No,
mentioned.
Whatever you want, you place it on.
Please,
I already obtained the endorsement from the Taluk office, my lord. There specifically stated there is no any permission prior to alienation of the land.
Let us see. Government, you verify. Yes, both sides to file their synopsis. Yes.
58, wait, I'm waiting.
Right.
Lords, filed an application to take out notice on respondent number 6 by the way of paper publication.
How many times you have taken?
3 times I've taken.
The petitioner submits that respondent number 6 has been evading service of notice. Full stop. In light of the amendments made in the application, IA 1 of 25 is allowed. Petitioner is permitted to take out notice by way of publication in Kannada Daily Samyukta Karnataka Bangalore edition by publishing the same, showing the date of hearing.
17th.
Yes.
Subsisting interim order may be
Yes.
extended. Interim order may be.
Interim order and operation extended till the next day.
Much obliged.
59. Power Secretary, 59.
For the petitions, my lordships.
Yes.
My lordships, we have filed an application to bring in the LRs of R5 and R6.
Notice must go.
Yes, my
My lord,
lordships.
But I appear originally, my lord, for response 5 to 7.
You will accept.
But I
notice.
have, yes,
You'll accept notice.
I will accept and I will file wakalat also. It may be allowed.
We'll allow them.
Murli.
Murli, yes.
IA, you have filed 2 sets of applications.
My lordships, there are three
Three
IAs.
applications, my lord. No.
No, for both of them you have filed.
No, respondent number
lordship-
5, Lord, is represented by 6 and 7.
No, who has died now? 6.
5 and 6
5 and
are
6,
died,
both of them
have
have
died,
died.
my lordships.
Have you filed applications for both?
My lordships, the LRs of R5 are already on record, R6 and R7.
I have stated, my lord, in my memo.
That will accept.
Yes, yes, that's correct.
It is noticed that R5 has died and counsel for the fifth respondent who represented fifth respondent when he is alive submits that R6 and R7 are the LRs of R5.
R5.
Full stop. In light of the same, R6 and 7 are hereby ordered would represent the interest of R5. Necessary endorsement to be carried out in the cost item. Insofar as then who
R6, my lord, has also died on 7/10/2024. For that, my lord, the application is fine. That may be allowed.
ಅದಿರಿ ಒಂದು ನಿಮಿಷ 5 ಇರಲಿ ಒಂದು 5 ಹಂಗೆ ಇರಲಿ ಆರ್ಡರ್ it is submitted that R6 died
On 7/10/2024. Along with the memo, I have filed the death certificate.
R6 it submitted that R6 died on 7/10/2024. IA 1 of 25 has been filed seeking condonation of delay in filing application to bring LRs of R6 on record. IA 2 of 25 is being filed, set aside abatement, and 3 of 25 for bringing LRs of R6 on record. Third counsel, Shri B.S. Murli undertakes to file wakalat for the said legal representatives and submits that applications may be allowed. In light of the facts as made out and stand of counsel who undertakes to appear for the proposed LRs, I1 of 25 is allowed. Delay in filing application to bring LRs on record is condoned. 2 of 25 is allowed, abatement is set aside, and 3 of 25 is allowed, and the proposed LRs of R6 are permitted to come on record and represent the interests of R6. Next. It's submitted that R5 has also died. Learned counsel who is appearing for R5 prior to his death submits that the LRs of R5 are already on record by way of LRs of R6 and respondent number 7. And it submitted that the court may order that respondent number 7 and the LRs of R6 could be treated as the LRs of respondent number 5. In light of such stand, it's ordered that the LRs of R6 who have now been brought on record, comma, R7 would represent the interest of R5. Necessary endorsement to be carried out in the cost title. Necessary amendment to be made out. List after 2 weeks.
My lordships, a date may be kindly given.
Date may be fixed.
My
I have
lordships,
already filed my
interim order may
objections.
be kindly
Modern
extended.
operations extended to the next date. Next.
8th of December.
8th of
16th.
Applies now.
Harish Mallarati. 16th.
I was listed in the B group, Your Worship.
We are appearing for R6 and R7.
Status quo has been ordered, Your Worship, that has been now. We have taken up for hearing from B group ಅಲ್ಲಿ ತಕೊಂಡ್ರೆ
List. IA for vacating stay would be taken up in the stage of B group. List the matter in B group on
9th of December. 91. Gujarati.
Yes.
I'm placing the short list of dates which you also direct. And also those documents which you also also ask me whether they are available. The orders which you also were referring to. I provide a copy also to my learner.
You have filed a vacating stay.
No, that's
Yes,
my
my lord.
application vacating state, yes.
So what is your case now?
My lord, my case is this. My lord, kindly consider.
How much time will take?
My lord, about
Little longer.
15, 20 minutes.
Then you come at 4 o'clock, I'll take it.
I shall.
Pass over.
I shall.
For petitioners, the suit of spending, my lord, they sought the revenue entries after 20 years. My lord.
Yes.
It's the mother of the petitioner filed a suit for partition. Lord, the respondents are defendants. They presented a will, my lord, and sought, my lord, partition should not be happened. The issues as framed. No, my lord, after 20 years, my lord, 2002 is this will, my lord. After 20 years, they have sought the revenue entries. Kata, my lord, and there is no probate, my lord, and not been notice issued to us. The suit, my lord, annexure E, page 36, my lord.
No, you're challenging what now?
My lord, challenging annexure, my lord, the order passed by, my lord, the municipal council.
Under what provisions?
Lord, change of kata, my lords, and the provisions.
Revocation or what?
No, means they The Kata has been ordered to be mutated on his name based on the will executed in the year 2002. my lord.
Now, prior to this, in whose name it was standing?
It was in the name of my grandmother, my lord, Huchamma.
Where is that copy?
That's the annexure, my lord, page 14. The tabular column, my lord, they mentioned.
Yes.
Huchamma.
Yes.
My lord, my mother filed a partition suit, my lord, 20 in the year 20. Annexure page 36 is the order sheet.
Now, the respondent was a party in this
Please,
partition.
my lord, she is here. They are the parties. My lord, they are a defendant number 1 and 2, my lords. 37 pages, my lord, the plaint.
Ananda Biramma.
Please, my lords, who is my
Defendant number 1 and
2, my lords. This suit was filed on 11/3/2020, my lords.
11/3/2020.
2020.
What happened to this suit?
The suit is pending, my lord, and they have entered appearance and they said there is a will. And my lord, they sought dismissal of the suit on the ground there is a will. Issues, my lord, at page 70, Annexure G. Issue is also framed on the will, my lord. Issue number 3. Annexure G, page 70. Issue number 3.
Defendant number 2 is Shivanna.
Shivanna, my lords.
Shivanna is respondent number.
My lords, respond number, my lords, in this case is respond number 3, my lords.
And defendant number 1 is?
Is respond number 5.
Ananda Biranna.
Ananda Biram, my lords.
Now, this suit is still pending.
Is still pending, my lords.
Now, prior to that, it was in
It was in the name of Srimati Huchama, my grandmother.
Now, what is the finding by the revenue officer?
Lords, he said they made an application, my lord.
Suit is filed on?
Lords, 11/3/2020, my lord, suit is filed.
Now, application for change of kata is done subsequently.
Subsequently, application is made on 15/6/2020.
They are saying it should await the outcome of the suit.
No, my lords, they without disclosing the suit, my lord, they got their entries.
No, correct. So you are saying that it should be revoked.
Await by my lords, because 20 years.
Aside,
please.
And then it should remain in the name of Uchamma.
Please,
till the suit is decided. They have not revealed the pendency of the suit.
Suit, they are not, my lords. And my lords will.
Humble submission from respondent 3 and 4, my lord. If followed, I will. Followed, I will speak out, my lord. I am for respondent 3 and 4.
Yes.
I'll make my submission.
Yes.
My lord, the entire story is like this. The respondent number 3 and 4, respondent number 3, in fact, is the foster son of the.
No, that's on merits, sir. I'm saying OS 26 of 2020 is still pending.
Yes, exactly.
There's an issue regarding will.
Exactly.
Then how you can get your name entered without revealing the pendency of the suit?
My lord, the same thing is, the kata is made, the observation is made, kindly look into, my lord,
page.
on the outcome of annexure, my lord, that's fine.
You can't change till the suit is decided.
No,
you
no,
can't
my
say
lord.
subject
My
to.
lord, my lord.
That is all the BBMP official
Humble submission.
strategies.
These orders have been passed with the condition that outcome of the civil suit.
You can't do that. Once the matter is pending, you have to hold your hands.
Exactly, my lord.
By taking money, these BBMP officials can't do that and simply say subject to the outcome of the suit.
Exactly.
That very issue regarding the will is pending. Issue is framed. Court is to decide. Till then, it will be in Uchamma's name. Afterwards, it will go to.
Shall I take you to page number 67, my lord? 67. Written statement, my lord. 67, first line itself, my lord. Schedule A property on 28/2/2000 is presence of the son of the plaintiff, that is P.V. Manjunath, who is the petitioner here, my lord. And the matter for the same is signed on 12/3/2014 when the same P.V. Manjunath on behalf of the plaintiff and defendant number 1, who is none other than the son of the plaintiff and FP holder. He himself, who is the petitioner here, who is contending the share of his mother, he himself has signed the major representing the will that he is allocated such and such a share of the will. And he comes with, he doesn't have the knowledge of the will. This is because of the internal feud in the family. Internal feud has led into all this. they themselves very well know the will has been executed in the year 2002.
No, correct. Now that's a matter to be decided.
Yes, exactly.
Let it remain in Uchamma's name, and then let the suit Kata will be changed in terms of whatever the suit, whoever share it goes.
My lord, the thing is very simple. In revenue entries, it doesn't make the title pass, my lord. You also well aware of the.
That's a different matter.
Exactly.
But you should have revealed regarding pendency of suit.
It has been revealed to the revenue official.
Where is it in the order sheet?
Yes, yes.
It only says in the end, subject to the outcome. That they can't do that. They have to hold
My
that.
lord, humble submission. A week time is granted. I will get the instructions from my client, my lord.
What instructions?
Regarding the revealing of the.
Even if you have revealed, when the will is in issue before the civil
Page
court.
number 28, same thing is
So
mentioned.
correct. What is the hurry? Why did they effect it in your name? They could have waited till the
R1,
civil.
R1 should answer.
Let us see.
R1 is the one who is to
So
answer.
correct. Now let it be done after the suit is decided. We are only going to say that this order is set aside in light of suit having been instituted before this proceedings. The petitioner has called in question the order passed by respondent number 1 at annexure A, whereby the authority concerned has directed the transfer of mutation kata into the name of respondent number 5.
3 and 5, my lords. The two orders, my lords, annexure A and B, my lords. Two persons different, one also sought and two also.
For the respondent 5, my lord.
Annexure A and B are the two orders, my lords. Annexure A, my lords, in terms of annexure A, respondent number 3 name is mutated. In terms of annexure B, respondent 5 name is mutated.
Respondent number 3 and 5.
5, please.
By virtue of orders and proceedings at annexure A and B.
Please.
It is the case of the petitioner that applications for change of kata on the basis of will was made on 15/6/2020 as regards annexure A, and on 16/6/2020 as regards annexure B. It submitted that as on such date, on 11/3/2020 itself, OS 26 of 2020 was filed by the
Mother of the petitioner.
Mother of the petitioner, and the will relied on by the respondent authorities having been disputed is pending adjudication insofar as specific issue, namely issue number 3, has been framed by the civil court in OS 26 of 2020. Accordingly, it is submitted that the authorities ought not to have passed orders for effecting kata on the basis of will when the said will itself was disputed and pending adjudication in OS 26 of 2020. Learned counsel for the private respondents, however, would contend that the proceedings have, while the proceedings of the respondent authorities, while directed effecting kata on the basis of will, had clarified that such entry would be subject to the outcome of the civil suit, isn't it?
Right.
Full stop. Next, must be noticed that the kata earlier to the proceedings at annexure A and B stood in the name of
Srimati Uchamma.
Stood in the name of Srimati Uchamma, wife of Madhurappa.
Madhurappa, please.
Full stop. Said fact is not in dispute. The fact that suit for partition was filed on 11/3/2020 is also matter of record. In the said suit, the defendants have set up a will and claim rights under it. Full stop. Issue number 3 has been framed by the civil code, which reads as follows. Whether the defendant number 2 proves that Uchamma has executed a will dated 23/5/2002 in respect of C schedule property. When the will was in dispute, there was no warrant for the revenue authorities in rushing to effect kata in terms of the will without notice to the petitioner
No notice, no.
or the parties, other parties in OS 26/2020.
Please.
Not a number submission. Even the petitioner's name Kata is restored.
Huh?
According to the will, even to the petitioner's name Kata is restored.
That we'll see, let it settle, we'll see. Full stop. Next. Accordingly, in light of the above, the proceedings at annexure A and B are set aside. The entries pursuant to the orders at annexure A and B stand set aside. Kata would now stand restored to the name of Uchamma, wife of Madhurappa, and the same would be subject to the judgment and decree in OS 26/2020. Full stop. Upon judgment in OS 26/2020, the parties are to move the revenue authorities, the municipal authorities for effecting kata in terms of the orders passed in the pending suit.
Please, I'm
All
obliged.
contentions of both sides are kept open. ಅಲ್ಲಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಹೋಯ್ತು.
Grateful.
Last
63.
Better the petition. It's two applications I have filed, minutes. One is fixing the date for early hearing, minutes. And second one is I have been in possession of the property. They have not given an electrical connection, minutes. Therefore, first the application for considering my connection to the power may be concerned, minutes. Then your lordship, not a convenient date, date may be fixed so that we'll argue the matter.
Yes.
Lordship, again, since 1938, I have purchased the property, I'm in possession of the property. Then how can he construct a building on my property? Even there are so many tribunal orders. By suppressing all those facts, your Lordship will say, I filed this application.
That's page number.
Lordship may kindly fix the date for hearing. Main matter can be
My lords,
disposed of.
rightly or wrongly, I am in possession, my lords. My photographs also I have produced. I have built a small shed. I am residing there and also I am enjoying the possession of the property, my lords. I have also given an undertaking in an affidavit stating that in case if he succeeds, I am ready to vacate the premises, my lords. Till the pending disposal of this petition, my lords, let the power connection may be given. My lords, without power connection, a person in a village, how can he live? That's my humble submission. In case I will also ready to give an undertaking here before your lordship, my lords. In case if he succeeds, I will give entire possession to the property, my lords. I have no choice.
Power will give him, power connection will give and will fix a date.
Please,
that should be.
How can your Lordship, even there is no shed at all. They are
Photographs
not
I
shed.
have produced. I have produced the shed.
He has produced some photos where it is. Your Lordship can say there is no shed, even there is no, even it is an agricultural land. 1938, I have purchased the property.
Kindly peruse.
If the electricity is connection according to them, then they will put up a shed in my property and your Lordship will see, he will prove that he is in possession of the property.
Well, that's only point for consideration before your lordship with regard
When
to.
the shed was constructed,
well.
why has not taken the electricity construction since from the day?
I'll fix a date, let us see.
Please fix a date.
At least
Yes,
temporary connection may be provided.
correct, but they're disputing your possession.
Please.
And then possession is recent. I is allowed, list the matter in B group on.
2nd of December.
Second?
2nd of December.
Obliged.
Eighty-nine, which is only a mandamus matter.
I'll come back, you just, 230 you make a mention. 230 you make a mention. Mandamus you write and give it, we'll take it out of turn.
Yes.
Is there any mandamus of councils? You can write the number and give it to the court officer. If you don't take it today, we'll take it higher up in the list on a day. Mandamus only.
Yes, ma'am.
Sir, 64.
Professor.
Pass over. Pass over matters. Serial number 9. Sridharake.
Serial number 68, man. Serial number 68. Today I have received the expedition copy and annexures, my lord. I will file wakalat on behalf of respondent number 6, my lord. Mr. P.V. Chandrasekhar is appearing for petitioner.
You have informed him.
Respondent.
You have informed him.
I informed him.
At request. Have you informed the other council?
My lord, other council? No, my lord, petition council I informed, my lord.
Dhananjay Joshi.
Today I have received the papers. And
Respondent.
I undertake to inform, my lord.
68.
Because some vacating stay is filed.
My lord, I am for respondent number 6. It is served, my lord, only.
Otherwise when it reaches, I'll accommodate.
Please, please, my lord.
Pass over matters. Serial number 9. Sridharake.
ಇನ್ನೊಂದು ದಿನ ತಗೊಳ್ಳಿ.
24th.
ಈ ಲಿಸ್ಟ್ ಬರೀ ಪಾಸ್ವರ್ಡ್ ಕೇಳಿದ್ರ 9 ಪಾಸ್ವರ್ಡ್ ಆಯ್ತು ಪಾಸ್ವರ್ಡ್ ನೋಡಿ ಬಂದಾಗ
27.
This is the matter wherein your lordship directed the government advocate to secure the instructions whether it can be disposed of in a time-bound manner.
27.
And Madam Navya was telling that because she has the instruction to dispose of them, to get the direction to complete it within 2 months, my lord.
Let her come, I'll dispose.
Please, your lordship, please.
Password.
30. Yashodhara Hegde.
I appear for the petition, my lordship, in this matter. It's a petition for mandamus, my lordship. What has happened is, my lord, I am the sole legal heir of the my father. My lord, my grandfather has purchased the property. It has been granted under the special land grant order. Thereafter, my lord, after the death of my grandfather, my father has inherited the property, and after death of my father, I have inherited the property, my lord. And
let them come, let them come. State must
please.
Badli government. Password.
42. Vivekananda.
Appearing for petitioner. But the petitioner was challenging the order passed by the second respondent, which is produced at annexure J.
Forty-two.
Yes.
It's the brief facts of the case is that minutes. Survey number 128 minutes. Totally measure 3 acre 32 guntas. Let's. It was in Enam land. There were 2 applications for re-grant of the land. The re-grant order is at annexure B. Can you see page 34 minutes? The relevant portion is at page 35. At the bottom, Roman 2 minutes. Srimati Pujamma, wife of Yellaya, was re-granted with 1 acre 35 guntas in survey number 128. The survey number which is the subject matter is 128 minutes. Let similarly, let Srimati Yellama, wife of Channappa, was granted with 1 acre 35 guntas in survey number 128. But based on this regrant order, mutation was effected on Annexure C, page 37. Lordships got it, Roman 2, page 37, Annexure C.
Yes.
Let's Roman 2, Pujamma, wife of Yellaya, survey number 128 P, 1 acre 35 guntas minutes.
Yes.
Same entry with regard to Srimati Yellama, 1 acre 35 guntas. But this position, Malad, is undisputed. But thereafter, Malad, based on the mutation entry, proceedings, the RTCs were written in the names of Yellamma and Pujamma with regard to 1 acre 35 guntas. But when things stood thus, Malad, in the family of Yellamma, after the death of Yellamma, they sought for change of mutation, Malad. Accordingly, it was considered. Kindly see, MR mutation proceedings at Annexure G, page 60. Insofar as Yellama is concerned, it's 1 acre 35 guntas. Okay, fourth line from the top, Yellappa, Dalappa, Nagaraju, they are the legal representatives of Yellama.
135.
135. 1 acre 35 guntas.
Pujamma is shown as 330.
That is total land in the entire survey number.
So what is Pujamma is again 135.
135 minutes. Yes, minutes.
But where is Pujamma's name shown?
Pujamma's name is not shown here, minutes. But in the RTC at Annexure H1, page 62. And 65 minutes H2. Yellappa, Dalappa, GY Nagaraju, bin Yellaya. 1 acre 35 guntas was shown. But as against Yellamma, it is shown as 00.
Yes.
That's in page 83 minutes. On their request, again, the names of legal representatives of Pujamma has been shown, 1 acre 35 guntas, and page 77, Annexure H11 minutes. Yellappa, they are the legal representatives of Yellamma, and Yellamma, wife of Channappa, 1 acre 35 guntas. That's the Annexure H13, you will also kindly see page 85. Let's here, the name of SV Gopal has been entered. Page 85, Annexure H13. As regards Yellappa, Dalappa, and GY Nagaraju, it is maintained as 1 acre 35 guntas. The another 1 acre 35 guntas was entered in the name of Sri SV Gopal bin Venkatappa, who claims to be the purchaser of 1 acre 35 guntas from the family of Pujamma. It is his claim that he is the purchaser.
Yes.
In Annexure J, page 87, the sons of Gopal, that is Narsamurthy and others, have filed an appeal before the Assistant Commissioner contending that prior to the regrant order, based on the original grant, they have purchased 2 acre 10 guntas from the family members of Pujamma, therefore entering the name of legal representatives of Yellamma, insofar as 1 acre 35 guntas is incorrect, their name should be entered only in respect of 1 acre, only 1 acre. That was the contention urged. And the Assistant Commissioner, let's passed an order, annexure J, page 87. But the operative portion is page 91.
Yes.
That's the relevant paragraph. Let's say is a page 90, second paragraph. May I read that one paragraph?
Yes.
ಎರಡನೇ ಪ್ರತಿವಾದಿ ಲೇಟ್ ದಾಳಪ್ಪ ಹಾಗೂ ಏಳನೇ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸುಳ್ಳು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಮೇಲ್ಮನವಿದಾರರನ್ನು ಪಾರ್ಟಿ ಮಾಡದೆ, ಒಂದನೇ ಪ್ರತಿವಾದಿಗಳು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸದೆ, ಸರಿಯಾಗಿ ವಿಚಾರಣೆ ಮಾಡದೆ, ಪ್ರತಿವಾದಿ ಲೇಟ್ ದಾಳಪ್ಪ ಏಳನೇ ಪ್ರತಿವಾದಿಗಳಿಗೆ 1 ಎಕರೆ 35 ಗುಂಟೆಗೆ ಖಾತೆ ಆದೇಶ ಮಾಡಿದ್ದು, ಇದರಲ್ಲಿ 35 ಗುಂಟೆ ಸಂಪೂರ್ಣವಾಗಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಸೇರಿದ ಜಮೀನಾಗಿರುತ್ತದೆ. ಈ ಜಮೀನಿನಲ್ಲಿ ಪ್ರತಿವಾದಿಗಳಿಗೆ 1 ಎಕರೆಗೆ ಮಾತ್ರ ಹಕ್ಕಿದ್ದು, ಕಾನೂನು ಬಾಹಿರವಾಗಿ 1 ಎಕರೆ 35 ಗುಂಟೆಗೆ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಆಪಾದಿತ ಎಂಆರ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಸರ್ವೆ ನಂಬರ್ 128ರಲ್ಲಿ 1 ಎಕರೆ 35 ಗುಂಟೆಗೆ ಖಾತೆ ಮಾಡಿರುವುದರಿಂದ ಬಾಧಿತರಾಗಿ ಈ ಮೇಲ್ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ, ಆಪಾದಿತ ಎಂಆರ್ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋವನ್ನು ವಜಾಕರಿಸಿ, ಮೇಲ್ಕಂಡ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸರ್ವೆ ನಂಬರ್ 128ರಲ್ಲಿ 1 ಎಕರೆ ಹಾಗೂ ಮೇಲ್ಮನವಿದಾರರಿಗೆ 35 ಗುಂಟೆಗೆ ಖಾತೆ ಮಾಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. This was the request. According to them, the petitioners are entitled to only 1 acre of land, and they are entitled for 1 acre 35 guntas plus 35 guntas. But the Assistant Commissioner acceded to their request and passed an order restricting the revenue entries insofar as legal representatives of Pujamma as 1 acre, and remaining 35 guntas has been ordered to be entered in the name of the purchasers of the land. But pursuant to this order, the fresh MR was proceedings was initiated. Annexure K, page 92, restricting the revenue entries insofar as Yellappa and others as 1 acre. But this order was challenged by the petitioners in a revision petition, Annexure M, page 102. The order of the Assistant Commissioner has been confirmed.
Now this 35, how do they claim?
35 guntas minutes, they claim that much prior to the regrant order, when the original grant was made, the family members of the original grantee have sold 2 acre 20 guntas as against 1 acre 35 guntas. That they could not have sold in excess of what has been granted to them. That has been observed in the grant order itself. Kindly see the grant order annexure B. The typed copy is at annexure B. May I read minutes annexure B minutes. Page 34 minutes. Paragraph number 5 is relevant. May I read minutes. Since the Talwari service Inam land to an extent of 2 acre 30 guntas was alienated by some of the Hakdars, and same was in possession of one Sri Gopal, he was evicted from the same as per this court order of even number dated 21/9/1984, and the possession of the said land has been taken over to the government. Next, heard the applicants and peruse the records. the revenue records such as the IL and RR and the report of the revenue inspector supported by the village Mahazar and the genealogical tree of the Talwari and Niraganti families of Vallarli village collectively reveals that the applicants are from the Talwari and Niraganti families of the said village and that they were performing the duties of the said office till they were abolished. The statement of the applicants reveals that they are in possession of the scheduled land except those which have been alienated in the above. In the absence of rival claims, I am convinced to hold that the applicants are entitled for regrant of the scheduled lands. I therefore, in exercise of the power conferred on me under Section 5 of the KVOA Act 1961, regrant the Talwari and Niraganti service inam lands of Gollarli so and so to the applicants and other hakdars as per the genealogical tree as hereunder. This regrant order is very clear, my lord. Pujamma has been granted 1 acre 35 guntas and Yellamma has been granted 1 acre 35 guntas. Well, this order became final. No, my lord, nobody has challenged this order. But now the revenue authorities holds that the sale made prior to the regrant order in respect of 2 acre 20 guntas, based on which Mr. S.V. Gopal's legal representatives have sought for modification of the revenue entries, and at their request, the revenue entries are now restricted insofar as 1 acre in favor of the petitioners herein, and 2 acre 20 guntas in favor of the private respondents.
No, which inam this is, village officers or which?
Village officers abolition act.
But then it would, any sale
Yes.
would inure to the benefit.
Sale should be in consonance with the original grant. If grant is made for 1 acre, if they sell 2 acres, by virtue of the regrant order, they can't seek ownership over 2 acres of land. Now here in the grant order, it is specifically restricted 1 acre 35 guntas. And there is, please.
No, the point is, in case of that Lakshman Gowda and Bashir Ahmed's case, now who of you are the earlier, you claim through the original inamdars.
Yes, I am
the purchasers.
No, I am the grantee, I am the direct grantee.
Correct. So now the purchaser will he not be entitled to the benefit of regrant?
He is not the purchaser from our family. He is the purchaser from the other family, Yellama's family. We have not sold any extent of land.
So you're saying Yellama's is a different share?
Yes, no, in the,
they have the benefit of Yellama share of 135, but they're claiming the
2 acre 20 guntas over and above the order of regrant.
When Yellama was granted only 135.
Yes, Yellama and Pujamma both were granted 1 acre 35 guntas.
Each,
yes.
Each or together?
Each.
So they could not have, even if there was a sale,
yes,
it could not have been more than 130.
Yes, that is what the observation of the tribunal in paragraph number 5, that in excess of the grant order, there is a alienation. Therefore, he has been evicted and the land was taken back to government. And then the regrant order is passed.
Yes.
Therefore, the claim of the purchaser S.V. Gopal over and above the regranted extent of land, that is unsustainable.
So now that is
Before.
Narsimurthy.
My lord, in annexure J, we are the respondents.
Respondent.
Yes, yes, my lords.
Respondent number?
Respond number 2 to 7 minutes.
Representing Yellappa and
Representing Yellamma.
Yellamma.
Yellamma, yes.
What about that other lady? That is
They,
not
they
an
have
issue.
sold it, my lord. They have sold it to.
That is not an issue.
Not an issue.
Only for-
The appellants Narsimurthy and others are claims to be the purchasers from the other grantee.
Pujam.
Pujam. Pujamma is our ancestor, my lords. Yellamma is the vendor of the appellants.
Yes. No other contesting party is put in appearance.
That they have not represented. They were served with the notice.
Facts have narrated here in the synopsis.
Synopsis, clear, please.
Yes, government.
Here, my lord, the finding of Gopal being the person is at page number 31. The connection. B. Since the Kalwari service Imam land extend to the extent of Idolita. Thereafter, my lord, I read para number 7. Para number 7 in the same.
You read the typed copy. Next is the typed copy.
The revenue records, such as the IL and RR and the report of the revenue inspector supports by the village manager and the rural secretary of the Kalvari and Neergante family of the Kalvari village collectively reveals that the appellants are from Kalvari and Neergante family of which the villages and that they were the performing the duties of the said officers till they were abolished. And that after Gopal purchasing 2 acres 30 guntas, subsequently re-grant was made, but Gopal has purchased from
Gopal has purchased from
Yellamma. Yellamma's family members, not from Yellamma.
Neergante family means one family or it can't be a multiple family. But I say that it might be if any one of the family members are this Pujamma has involved in the sale deed.
Do you have a copy of the
Sale deed.
Sale deed, Devna?
Yes, I have one. It's not typed, handwritten copies.
Who has sold?
So Gopal has purchased otherwise I'll have it tomorrow in the preliminary hearing list.
That would be the relevant.
You make one small note.
Yes.
And then you point out Gopal has purchased from whom how much.
Yes.
And then the 2 branches of Pujamma and Yellamma, and that the sale to Gopal, if by Pujamma, only to the extent of 135 will hold good. Anything in excess of 135, since it's not sold by Yellamma, cannot be given effect to. And then what is the modification of the mutation? First 135, 135.
Yes.
And subsequently, after the AC's order, it was modified.
Yes, it is modified. Till the Assistant Commissioner passes the order in 2018,
it's correct.
the revenue entries were intact in terms of the grant order and the mutation proceedings effected in the year 1990. minutes, 1984.
So they just check from the sale deed. Gopal is purchased from
ಬೈಲಪ್ಪ ಮತ್ತು ಎರಡನೇ ಸಿದ್ದಪ್ಪ.
Let's in the annexure A, let's in the proceedings, it is recorded, let's page 28.
Correct.
Typed copy, let's of the.
But he's raising some ambiguity, so just check on that one point.
But in the last line of this schedule itself, ಹರಿಜನಗಳ ಲಿಂಗಪ್ಪನವರ ಮಕ್ಕಳು ಒಂದನೇ ಚಿಕ್ಕ ಬೈಲಪ್ಪ ಮತ್ತು ಎರಡನೇ ಸಿದ್ದಪ್ಪನವರ ನಾವು ಬರೆಸಿಕೊಟ್ಟ. He has purchased from two men, Bailappa and Siddappa, first and second. Here, Bailappa.
That you just check and have.
Yes, minutes, tomorrow.
Delist the matter in the preliminary hearing list tomorrow. So you make a note, so for dictation it will be.
Please.
It depends on that.
Huh?
The crux of the matter is the sale deed. If they have any one of the member is sold that,
Even if,
he perfect its size.
even if there is alienation in excess of the grant made, that would not inure to the benefit of the other grant. And they cannot reduce my holding based on their excess sale deed.
You just refer in that note to the
I shall do it.
mutation of each of them
Yes,
individually. Yes.
Family tree of all the two Pujamma and Yellamma is necessary. They are not.
No, that is also recorded in the assistant in the tribunal's order itself, page 27. Typed copy is at page 29.
We'll see.
I'll just look.
Tomorrow.
Only that.
Yes. Election matter. ಅದು ಯಾವತ್ತು
Serial number 1, Anil Shekhar. Serial number 1, Anil Shekhar.
We don't even have one file also.
Copy of petition, sir.
ಇದು ಆಶ್ರಯ ಸೈಟ್ ಎಲೆಕ್ಷನ್
For the court orders, we had prepared the list you.
Have they furnished it? They furnished, is it?
Sorry, Milord?
Have they furnished some table to you?
Just now, Milord, I just received it. This is only to indicate that they have given representations. In 2023, even though their allotment I see is in 2008, they keep quiet till 2023. The entire case of the government is to say that right from the date of allotment till the date of the impugned order where we cancelled it, what all irregularities have happened place in not constructing, in not seeking for any amenities, people we have identified to be owners of other lands and people who are in government employees and things like that. My understanding of the things which have been given is only to indicate the writ petition number, correspondingly the name of the petitioner or the beneficiary, the date of allotment and the date on which they gave a representation in 2023.
No, but you have to now in effect file a rejoinder to the statement of objections. Now their statement of objections, you just go to the statement of objections.
My statement, Milord?
They have raised as regards each person what the ineligibility is. Now you'll have to file a counter to this table. Huh?
My lord, last occasion I had given a tabular format. The same thing will incorporate and we'll file a detailed rejoinder for all the contentions taken by the state, my lord. in this.
Now just look at it. Bhanu Prakash, you just point out one or two so
Please.
that they'll know what they have to meet.
Yes, Manoj.
Take your statement.
1 second.
Even there are some electricity bills, electricity connections, and we had also informed in the list itself.
Statement, good, sir.
My lord, we may be permitted to provide this the tabular form that the court had instructed us to provide.
In fact, Manoj, we have only reiterated in our statement of objections what is indicative in the impugned order as to how many people, I mean, what is the irregularities based on which the impugned order came to be passed.
Extra copy.
This past
I mean, statement of objection it is.
Now you just point out
Yes,
what
Manoj.
is it they have to meet.
Yes,
So that
Manoj.
let them know when they're filing the rejoinder.
Yes, Manoj. If annexure from annexure R1, if it is taken, Manoj, or rather they can even rely upon the my preliminary submissions which I made. Even that, if they are able to come out, Manoj, para numbers 4 onwards, Manoj, page number 2. The first thing I've indicated is they have alienated to other persons subsequent to their allotment without the permission of the government. The government employees have made a false undertaking and got allotments of the properties. Multiple allotments within a single family. Failure to construct the house which is in condition. For 15 years they have not done anything else. These are the only things, Manoj, based on which the impugned order is issued.
For each of them you have written.
Yes, Manoj. I've given a tabular column as to what is the thing on basis on which we have rejected each one. Manoj.
Each of it you will have to meet. Each of
Annexure
it.
R1 in the R5 or R5 I have given individuals. For example, annexure R1 Manoj would indicate that the alienation has been made without the permission of the government.
So now what you have to do is you have to make a table. You on the left hand column, you put the stand of the government.
Please.
On what ground you are disqualified. And on the right hand side, you put your version in a tabular form for each of what the government is pointed.
Nan, I have bifurcated each one annexure R1 to R5. So they probably have to refute to
You will have to have a counter by having a parallel table to each of what the government is.
Please, my lord. Last occasion I had given, we will collect all the detail with respect to that and file a detailed rejoinder for.
That when you look at the table, their contention and your contra to that.
Please, my lord.
When do you want?
Next week, December 1st week would be fine.
We're still in 18th, Manoj.
27, 28 is.
26, 27th, Manoj.
28. 28 is what? 27th I have not. 28th would be fine.
Monday. 1st of December.
Please.
The petitioners to file a counter affidavit meeting each of the assertions of the state in the statement of objection. The state has asserted that the petitioners are disqualified and their allotments are liable to be cancelled on various grounds as mentioned in R1 to R5
please
of the statement of objections. The petitioners to take their stand regarding the same by way of a counter affidavit. Relist the matter on first. Interim orders in operation extended till the next day.
Great.
Stay extension.
Serial number 2. Yes.
My lords, the interim order referred to by them on the last date of hearing.
May I request one
Yesterday
thing?
it is vacated is what.
My lord, copy.
I have not yet uploaded. It's vacated and the court has said to argue the matter because the earlier matters have been disposed of. It's dismissed. So in view of the same, he said you argue freshly. And,
Interim order ಕೊಟ್ಟಿದ್ದು
I have
vacate ಆಗಿದೆ
filed
ಅಂತ
my
ಹೇಳ್ತಿದ್ದಾರೆ.
statement, my lords, to the amended petitions. You served, mailed the copies to them. The matter is to be heard now. And today some people are serving amended petitions.
Okay, let us see. But now, what about the election? Whatever
Please,
the
my lords, now
progress?
the last date I submitted that the draft ward-wise reservation is already filed. We are waiting for 15 days time has been given for objections. The minute we receive, we are going to notify the final draft. It will be given to the State Election Commission. Then they will start the process.
ಸುಮ್ನೆ time ಮಾಡಲ್ಲ.
So then when can you give the further progress?
Maybe next Monday, my lords, will by that time 15 days will be completed. We'll maybe 10 days, my lords, date after 10 days.
This one we'll see. Now you have finished your 5 years, we'll hear it, let us see. After 5 years, it's doubtful if you can continue, but I can hear you. We'll monitor whatever the
Please.
election one every 10 days
Please.
and then see what is to be done.
Lords, so far as this appointment of administrator is concerned, my lords. Lords, what the state is trying to do is they are signaling out Article 243U of the Constitution of India, my lords.
That's your version, let us see. But after 5 years, prima facie, you have no right to.
Lords, may I draw your lordship attention?
No,
to
we'll hear it. We'll fix a date and we'll hear it.
Today, my lords, because
Not
we
today.
are.
No urgency in this. You have completed your 5 years. Beyond that, you have to make out a strong right.
Lords,
to
we will
continue.
make out, lords, your lordship may kindly.
Let us see, we'll fix a date, we'll see. Next Monday, we'll start. Before you start, you must file a written synopsis after serving on the other side. And then we'll see. Prima facie, I am not inclined to give any protection beyond 5 years. State itself should have held election, which now we are monitoring. Beyond 5 years, you can't as an elected body continue beyond 5 years.
Lords, these 5 years.
Whether they have the power is a different matter. Now they are saying under removal of difficulties clause they're doing, that appears to be the only way for addressing the situation. The fact that the state is at fault cannot lead to your extension of constitutional 5 years.
My lords, your lordship may kindly appreciate in this pattern. Why this part 9A of the Constitution was introduced? These
hear it.
Municipalities,
You
lords,
file
are
it.
self-governing unit.
I'll hear it. You file
Lords,
a
it will make it abundantly clear before your lordship that the statement of object and reasons of the 74th
So
Constitution.
that will hear, but you cannot continue after 5 years. How can you continue after 5 years?
Lord, this
Your term is only for 5 years.
term was 5 years
So you
from the
file
date
your
of the
written-
first meeting, my lord.
File your written submissions and Monday we'll hear the matter. File your written submissions, your synopsis.
I appear in 2.14, 16 and 21. The administrator appointed in the category is already fixed. But I'm not so much on the extension of the appointment of administrator. Let the government give the roadmap of the election to the councillor and also to the chairman and vice chairman. Let there be some discipline at least
No,
this
correct.
time.
Correct. So last time,
That's all we are requesting.
no, correct. So last time we had passed an order in which they've furnished a schedule.
Yeah, the
Last
categories
time.
are this.
That you just have a look. They've furnished a schedule. So for further steps, the election commission and the government had a meeting pursuant to the order of this court, and they've given one schedule that you have a look at it. For further thing, they want next 10 days, insofar as delimitation is concerned, they've already published ward-wise reservation, delimitation.
In fact, my lords,
delimitation.
it appears election commission has filed a public interest litigation, my lords, to
that's okay.
fix
That's
reservation notification
We
for
only
urban
want
local bodies.
The election to the councillor and followed by the chairman and vice chairman.
Yes.
President and vice president. That's all we request. So for us 2.14, 16 and 21 is concerned.
No, so that
Let there be some, there, that's all.
So that we are monitoring it.
Yes,
You have a
upfront
look
I am
at,
grateful.
you have a look at what they have filed.
Yes, yes.
So the next one, I'll fix a date to see what further progress.
After 10 days, my lords.
No, my lords, on submission, my lords, in 2.24, my lords. My lords, the period of 5 years, my lords, started in the month of April, my lords, 2021. My lords, the first meeting was held, my lords, in the month of April 2021, my lords. In view of an order of interim order of stay, my lords, passed by the Honorable Supreme Court. The results, my lords, of the election was not announced, my lords, till 29/4/2021. If your lordship kindly peruse, my lord, my petition.
But these
I
three,
take your lordship, there are 4 petitions. my
there are
lord.
4 petitions. Your lordship may segregate that, my lord, hear it separately.
Yes.
Because that will, my lord, will be able to convince on that point, my lord.
Which are those 4?
My lord, 2.45.
2.45. Yes.
2.51.
Yes.
2.24.
2.24. And 2.28. Now in these 4, you are saying it's premature.
My lord, the calculation itself is wrong, my lord. They should have calculated from the date of announcement of result. Their announcement of results prescribes, my lord, everything what has happened, why there was not announced the result and all. My lord, and the first term, my lord, with regard to 30 months, which they have to consider, they themselves considered, my lord, 30 months they have calculated from the date of, my lord, the result, announcement of result. Now they cannot say that we are calculating from the date of meeting.
Okay, you have a look at these 4.
These
These
4
four,
matters,
my lord,
I'll file separate statements.
Dealing
It may be dealing.
And then you file a separate
Please.
statement.
That your lordship may have it day after tomorrow, my lord.
Till when it will go on? Till when?
My lords,
you
till
have
the month
term?
of April
April 2026, my lord, we have term.
Because there was lapse, my lords, of 6 months, my lord. The duration.
Now you have a look
This,
at
my lords, may take it up on Monday. Rest, my lords, after 10 days, I'll file my objection.
Now,
Rest
so far
also,
as,
my lords,
my lord,
rest
just 1
also.
minute. Now, in so far as these,
Please.
in case what they say to be correct, and from your records, if it is so, then you can take a.
I'll place the records, my lords. My
Correct.
lords may take an act.
So in case
Necessary.
what they say to be true, and if it is on verification found to be, then that an exception could be.
That 4 matters, my lords.
Uh, just wait. 2.4. Just wait. 2.45, 2.51, 2.24, and 2.28 are dealing from the present batch of matters and directed to be listed on Monday. These will go before the regular bench. But I'll make a mention of it. I'll make a mention of the insofar as such of these matters, counsel for the petitioner submit that their term of 5 years has not yet completed. Has not yet completed. The additional advocate general submits that they would look into the specific assertion of the petitioners insofar as each of these matters and take a stand.
Please.
Relist on Monday. On
2.24, an application.
That we'll see. That I'll take it up along with this.
In 2.24, my lords, an amendment application is filed, my lord. Lordship may kindly allow, my lords, my application, my lords. I have challenged, my lords, the notification between 6/11 2.24. 2.24.
ಈಗ ಅಲ್ಲಿ
2.24.
ಅಲ್ಲಿ withdraw ಮಾಡ್ತೀನಿ.
That amendment will allow. IA 2 of 25 for amendment is allowed, taking note that the amendments relate to subsequent events.
Please.
The amended petition to be filed.
Copies may be kindly
Copies-
served on us.
Copies to be served on the state. Amendment, the rest of those, I'll consider it on the date when I'm hearing the argument.
Item number 2.13
Yes.
may kindly be deleted from the batch, my lord. It pertains to a matter under the Corporation Act.
2.13
13.
is directed to be deleted and listed before the appropriate bench.
Please.
Then which is the next date?
My lords, after 10 days and it is.
Monday,
Not
my
10
lords,
days,
not
my lord.
10 days.
5 years you have finished.
No, it's not 5 years.
We'll
my lord.
hear it, we'll hear it.
The 243U and even that Tomar judgment, it clearly says there will not be any government official in these local bodies. That would be the, in every sentence, that is the intention of the constitution.
But how can you continue after 5 years?
It would be because the lab that duty is cast on them to keep the next body ready.
That we'll see. We'll consider.
As senior submitted, my lord, the whole intention of the 74th amendment, my lord, seems to see
That we'll
that
see. That we'll
there is
see.
no interference from the state government, my lord.
No, not after five.
These are self-governing democratic
Not
units.
after 5 years. Let us.
Lords, lords,
I'll consider.
if your lordship sees those
We'll
constitutional
consider.
provisions, my lord.
We'll consider. We'll consider. Both of you are at fault, both the government, and you cannot get benefit of default by the government. Yes.
First
No,
of
but it is a worse off situation to give the power in the hands of bureaucrats who is directly under the control
That
of the
we'll
state.
see. That's
That
a-
was the whole object of this 74th amendment, my lords, of introduction of part 9A of the
We'll
constitution.
hear that. We'll hear that. Relist 10 days correct.
first of first week
Huh?
of this.
All the amendment applications may be allowed. my lord.
Correct. So what you do now, petitioners, you make a table. One
Yes,
of
ma'am.
you just sit.
Please.
You say in which of them amendment applications are there. You make and give it to the
Please.
court officer.
Yes, ma'am.
The memo filed on behalf of the petitioners is taken on record. Details of the application for amendment have been spelled out. Taking note that the amendment application has been filed in light of the subsequent event.
Yes.
Said applications are allowed. A necessary amendment to be amended petitions to be filed.
Amended petitions.
To be filed.
Yes.
Yes. Relist. Second,
Please.
the state government meanwhile to file their status report regarding the progress made to hold elections.
On second, we'll come up with the synopsis and start with our argument.
Let us, yes.
On submission, 2.54, I filed a wakalat for respondent number 4. My name is not shown in the columns. 2.54. For R4, I already filed a wakalat. 2.5.
2.54. You have filed wakalat for
R4.
learned counsel so and so. Submits, he has filed wakalat for R4. Office to show the name of so and so is representing R4. Yes. Yes.
Continuation.
Second December. Great.
Second of December.
ಇದ್ರಲ್ಲ ಬೇರೆ ಈ ಕೇಸ್
Continuation 65. A.V. Narasimhan.
ಅದರಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಇದೆಲ್ಲ local body ಇದೆಲ್ಲ synopsis to be filed
Number 65.
listing the legal contentions with specific reference to provisions of the legislation as well as constitution relied upon, judgments in support of their contentions as regards power to continue even after the expiry of 5 years. Huh? The state also to take their stand by filing appropriate synopsis.
Continuation, serial number 65, A.V. Narasimhan, Vasantappa.
My lord, matter may be taken up in the next week, my lord.
Interim order earlier granted is extended. Relist week after next.
Interim order may be issued.
66, Leela P.
Your Lordship, I appear for petitioner. In this matter, Your Lordship, I sought for a direction to conduct 4D and Hadubast. Insofar as the very same land, adjacent land is concerned, Your Lordship, this one report directed them to conduct 4D. And as far I know is concerned, it's been, they have completed the 4D work. And Your Lordship, annexure, annexure D, my lord, page number 21. The relevant portion is available at page number 24. This is insofar as survey number 108, 6A, 6C.
Now your survey number is?
108, my lord.
108.
Yes, Your Lordship, very same survey number. So in this case also, Your Lordship, they have started, they commenced the 4D work.
They have commenced.
They have commenced. As of now, after filing this petition, Your Lordship, they have commenced the 4D work. They'll have to conclude it.
Yes.
Can I seek instruction, my lord?
You find out.
Tomorrow, day after, my lord, I'll.
This is the matter in the preliminary hearing list on 24th.
Please, Your Lordship.
67.
For the petitioner. Simple.
Pleading applicant in this case.
Right. This matter, petitioner got granted the land right, in 1978, please, my lord. Till 2000, RTC was in revenue entries was entered the name of petitioner. After computerized, my lord, they have left out the name of the petitioner, please, my lord. Hence, petitioner filed a mandamus. Lord, this court issued a direction as per annexure Q, page number 68, please, my lord. Page number 70 is the operating portion, please, my lord. Page number 70, para number 4, please, my lord. Consequently, writ petition disposed of. Specific direction respondent number 4, Tahsildar to consider the representation given by the petitioner and in light of the observation made in here and hereafter, verify the original records and pass the necessary orders. Enter the name of the petitioner in the revenue records expeditiously as possible and regularize the occupation, please, my lord.
I am for the impleading applicant, my lordship.
The same was not done. Annexure X endorsement was given, please, my lord. Page number 83. 86, please, my lord.
What is the endorsement?
Lord, 86 in typed copy, please, my lord. Last para. ಮುಂದುವರೆದು ಈ ಬಗ್ಗೆ ಕಚೇರಿ ಅಭಿಲೇಖ ಶಾಖೆಯಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳು ಹಾಗೂ ಕೈಬರವಣಿಗೆ ಪಾಣಿಗಳು ಪರಿಶೀಲಿಸಲಾಗಿ ಸೋನ್ಸೋ ಪಾಣಿ ಮಾತ್ರ ತಮ್ಮ ಹೆಸರು ನಮೂದಿಸಿದ್ದು ಉಳಿದ ಸಾಲಿನಲ್ಲಿ ನಮೂದಿಸಿರುವುದಿಲ್ಲ. ಕೈ ಬರದ ಪಾಣಿಗಳು ಕೊನೆಯ ಸಾಲಿನಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ 10 ಎಕರೆ ಮಂಜೂರಾಗಿದ್ದು 18 ಎಕರೆ ಉಳಿದಿದೆ ಎಂದು ನಮೂದಿಸಿರುತ್ತಾರೆ. 1967-60 ಸಾಲಿನಲ್ಲಿ ಕೈಬರದ ಪ್ರಾಣಿಗಳು ಲಕ್ಷ್ಮಮ್ಮ ಭೈರಪ್ಪ ರವರಿಗೆ MR ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಮೂಲಕ ಮಂಜೂರಿ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕಡತದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿ ಪ್ರತಿಗಳು ಚೆಕ್ ಲಿಸ್ಟ್ ಸೋನ್ಸೋ ರಾಜ್ಯ ವರದಿ ಇರುವುದಿಲ್ಲ. ಬದಲಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಆದೇಶ ಪತ್ರಗಳು ಮಾತ್ರ ಲಭ್ಯವಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಈ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಅರ್ಜಿಯನ್ನು ಖಾತೆಯನ್ನು ಮಾಡಲು ರಹವಿರುವುದಿಲ್ಲ.
What happened to that 136(3) proceedings?
They have never initiated at all, please, my lord. As on today,
Yes, government, what is your stand?
only one submission, page number 62, please, my lord.
Government have not filed the statement, is it? Page 62,
please, my lord. With respect to My lord, wherein 1978, there are 8 grantees along with petitioner. One of the grantee, one who missed the name in the RTC, he has approached the deputy commissioner. Tahsildar has filed a report there, page number 62, my lord, para number 2. ಮುಂದುವರೆದು ಅರ್ಜಿದಾರರ ಮಾಹಿತಿ ಹಕ್ಕು ಅಧಿನಿಯಮದಡಿ ಪಡೆದ ಸಾಗುವಳಿ ಚೀಟಿ, ಅಧಿಕೃತ ಜ್ಞಾಪಕ ಪತ್ರ, ದರಾಖಸ್ತು ನಕ್ಷೆ, ಆರ್ಆರ್ ದಾಖಲೆ, ಕೈಬರಹ ಪಾಣಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದೆ. ಇವುಗಳನ್ನು ಸೃಷ್ಟಿತ ದಾಖಲೆಗಳು ಎಂದು ಅನುಮಾನಿಸಲು ಬರುವುದಿಲ್ಲ. ಸರ್ಕಾರದಿಂದ ಅಧಿಕೃತವಾಗಿ ಮಂಜೂರು ದಾಖಲೆಗಳು ಎಂದು ಕಂಡುಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ದರಖಾಸ್ತುದಾರರು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳು ನೈಜತೆಯೇ ಸಮರ್ಥಿಸಿಕೊಳ್ಳುತ್ತದೆ. They'll take dual stands, please, my lord. While considering other petitioner, they'll take this stand. While considering my petition, my representation, they'll take this opposite stand, please, my lord.
Now you take your stand in writing. Government to take the stand in writing within 10 days. Release the matter on. Let them file, then we'll hear it.
I'll file their
At the
objection,
first instance,
please,
my lordship, I draw your kind attention to first paragraph of the endorsement, my lordship.
No, correct, but who
First paragraph of the endorsement very clearly states that, my lordship, he was not at all in possession, he was not at all cultivated, he was not at all granted the property.
So let them,
As on the date of granting, my lordship, he was aged about 5 years. That has been stated in the endorsement.
let the state take the stand in writing. Then we'll hear it.
Because ಅಲ್ಲಿ ಏನಾಗಿದೆ 6 acres ಅಷ್ಟೇ ಇರೋದು. I am in possession, he is claiming my property, my lordship. On the case.
Let us, please, let the stand.
I'll file objection for impleading application, please, my lord.
Yes.
68, Chandrasekhar PV.
Today I received the case papers, my lord, from the advocate, Sriranpatna. I have to file wakalat, my lord. Wakalat is ready. I'm filing in the office, my lord. Respondent number 6, my lord.
So and so undertakes to file wakalat for respondent.
Rajeshwar. Respondent number 6.
Interim
Order granted.
Well, I appear for the respondent number 7. I have filed an application for vacating the interim order granted, my lords. The seal deed is in my favor. The DC has correctly said that, okay, the revenue entries has to be in the name of the person who has this title.
Let us see now, the respondent 6 and 8 are putting in appearance.
6 and 8 are not concerned with this, my lords, because they are the family members. One of the family member has sold the property in my favor. There is a court degree and the court has executed the sale deed.
Are rejected.
Civil suit.
Partition suit pending. In spite of that, they alienated. The 7th response of party is there. That's why Tahsildar rejected it. Deputy Commissioner reversed it. That's why before let him appear as well, I will file argue on merits.
2005 is a sale agreement, my lords. The partition suit is filed in the year 2021.
Let us see, you are not visible. On that ground, I am adjourning. Relist on.
My lords, now my
Let
lords.
us see, I'll fix a date on the next date you start. Through
Yes.
VC, it's okay. I'll fix it on the next date you.
A short date, my lords.
Yes, relist on.
After 2 weeks.
8 of December.
8th.
69.
For the petitioner, my lords, as a request for a short date in this, my lords, we are led by senior counsel. Is not available today, my lords.
I may be extended. Interim order may be extended.
68 interim order earlier grant is extended till the next.
In serial number 69.
For the petitioner,
I represent
yes.
private respondents number 2 to 5, madam. I have filed application for early hearing.
Relisted.
The interim order may be extended.
Interim order earlier granted is extended till the next date. Yes.
Kindly a date may be given, madam.
9th of December.
Yes.
70.
Appearing for petitioner, my lord. Seek a week time. We will file objection to the IM, my lord.
Appear for this writ petition is infructuous, my lord. There is no order. Even prior to the purchasing, this land was not granted. In the year 1951, land was granted. 52 it was mortgaged. He purchased it in the 1953. After purchasing of the land, this land was granted, possession certificate issued. From the date of 1953 till today, this RTC is in our name.
You represent
No, respondent number 4 to 13.
grantee.
Grantee 1 acre land is granted in the name of 4 persons. Kenchaya, Elavaya, Kadaya, Kalidasaya. Only one person sold in 13/6/1953. Grant certificate issued on 30th/6/1953.
You take your stand. If that is their contention, that the sale was prior to the grant, you also take your parawise and file. A statement of objections to be filed within 2 weeks.
Interim order may be extended, my lord.
Interim order earlier
Well,
granted.
interim order, it is no use, my lord. What is the
Let us
interim
see.
order?
Let the state take the stand and then we'll decide matter on merits. IA 1 of 25 is disposed of.
Date may be given.
2025 matter, how you can take up immediately. You have to wait the older
Because-
matters. We'll see. Yes.
71. 71. Akshay Kumar Jain.
Officer held bid 25 matters, no IA for year. Held bid.
71.
IA for early hearing is disposed of. List after 2 weeks.
72.
This matter, madam, they have connected the matter. My matter is nothing to do with the second matter. My petition is under Land Reforms Act and their petition is under the SC/ST Act.
Your Lordship may see the order sheet. That very same submission was
Order
made
is
before
there.
your Lordship's predecessor bench. That submission was rejected because it forms a parcel of a larger same extent of land. It can be, of course, the issues are separate, but it can be heard together because it's a contiguous extent of land. That's all.
I appear for respondent 3 to 6, my lord.
24th September order.
No, any one by one will take.
Yes, one by one can be taken.
Yes.
I appear for respondents in 18848 of 25, my lord.
So what is the matter? What is the urgency for 25 matter to be taken up now?
There is a stay operating against us. We have filed an IA for vacating that stay.
In second matter, my lord, I appear for
This
second matter, I appear for the petitioner.
My lord, the clubbing of this matter is very irrational. First matter and second matter, though they are born out of the same survey number, there is no connectivity in the order passed by the.
There's no common order.
No common
No
order.
common order. They'll have to be heard separately. There's no doubt.
So then why club it? Then why club it?
Very well. It can be kept separately on the same day. It can be heard today. In fact.
And in my matter, maybe the records may be kindly be called for.
Not required.
LCR has to be called for.
We have examined the witness and no cross-examination. 34 documents has been marked. No cross-examination. There is no evidence from other side. And
It is PTCL granted land, which is why I'm submitting. They may have to be heard together.
Document to show that our property is totally different from the property involved.
You appear in the land reforms matter.
It's granted land, it falls within the scope of the PTCL.
The land was granted in the 88. Till now, the landlords have not questioned my land reforms order made in 88. Subsequently, in the 2015, the respondent number 5 filed a writ petition challenging the land reform order in respect of only survey number 143. The writ petition was allowed to the extent of survey number 143, and the land tribunal set aside the entire land tribunal order.
If my learned friend is saying he's not pressing 143, I have no objection. If that is the contention, I have absolutely no, because I'm only interested in 143.
Okay, file a synopsis, we'll see, but 25 matter, you'll have to wait.
The problem is, there's an interim order
Interim
stating.
order, my lord, is
He will-
contrary to the second round of litigation, my lord.
Correct. And in the PTCL matter, in fact, what Mr. Divakar saying is absolutely right. There was a larger extent of 3 acres, 26 guntas, where my lords, the entire alienation was challenged way back in 1989. Upheld by the AC, upheld by the DC. This honorable court said the orders are correct. The application was to set aside the sale with regard to 3 acre 26. Now, a smaller portion of that was sold to the petitioner in the PTCL writ petition. Now, the only question I ask myself is, if the original sale is held to be void under section 4, it cannot be that one smaller extent of that would not be void. The entire sale is void. If 3 acres, 26 guntas was sold to A,
petitioner, my lord.
A sells it to A, retains a certain portion, A sells certain portion to B. Now, if my sale to A itself is set aside, the portion retained by him is also void. The portion sold by A is also void. So it can't be that a smaller portion. So that is what the learned counsel for the petition and the connected petition is now contending. That I purchased only a smaller portion. The writ petition, the order passed in the writ petition in way back in 2002 applies to only another extent of land, even though it falls within the larger extent of 3 acre 26 guntas, which was set aside. It can't be that one portion is void, one portion is not void. If the alienation is void, the alienation is void.
But it has been questioned after 39 years, covered by Nikunti's case. I will place the facts, file the synopsis if you're.
1988 it was challenged for 3 acres 26 guntas. 1988 itself.
First sale?
The sale was in 1956.
39 years.
1947-48 was the grant. 1956 was the sale.
First sale.
Yes, with regard to the entire 3 acres 26 guntas. Now, my application was to set aside 3 acre 26 guntas, accepted by the AC. Now, within that 3 acre 26 guntas, the petitioner before your lordship today has purchased a smaller extent. If 3 acre 26 guntas is set aside, that nothing can survive.
The earlier round of litigation, I was given liberty. Question, my lord. After 39 years, my lord, they approached.
Delay?
I'm sorry, my lord.
Delay.
There's no delay. I applied, my lord may kindly see, next to R1, 1988, I applied for setting aside the sale with regard to 3 acres 26 guntas. If the learned senior says my land is outside 3 acre 26 guntas, it's a different. It's admitted that it's within the 3 acre 26 guntas. If I had originally filed an application only to set aside, let us say half of the 3 acre 26 guntas, and the other half I never sought, yes, delay would come in. But in 1988 itself, I said, please set aside the sale with regard to the entire 3 acre 26.
But in the writ appeal, my lord, matter has been remanded. Division bench has remanded the matter.
So all I'm saying is delay will not apply. Delay is no longer.
But the 3 acre proceedings has come to an end, is it?
My lord, I was given liberty to question them. My lord, whatever I have purchased in the earlier round of litigation.
That is both sides to file their synopsis. Real is the matter. But there is a connection between both.
It was the same grant. Original grant was the same. 3 acre 26 guntas is the PTCL issue. 2 acres is the land reform issue.
But in my case, he has approached after 39 years.
Both sides.
No, our land is purchased in 70. LCR has to be summoned by law regarding land reform. There is a allegation of fraud and concoction of documents. LCR of the land reform will be called.
Relating to the proceedings before the tribunal. Realist. Week after next date.
But interim order may continue.
Interim order in operations extended till the next day.
9th of
10th, my lord.
Yes.
Grateful.
Great.
Much of
23. CO.
Yes.
My lord, my instance, notice has been issued, my lords. I have filed complaint before.
He has no locus standi, my lords, to be party, my lords, to the proceedings between my lords, the Tahsildar and my lords.
Now, interim order is considered, not considered yet.
Interim order is considered, my lords. Now, by virtue of interim order proceeding with the construction, my grievance is this, my lords. He has encroached the public road and put up construction, my lords. That is my grievance. Only grievance that is he has encroached the public road. Kindly see my application, my lord. Annex R2.
Lords, I will file objections to his application. My lords, I will make my
Government
My lords, it's an, I have filed, my lords, Form 57 and 94C application, my lords, which is pending consideration.
I'm not
With respect of the
concerned
same
with this
survey.
construction of house, my lord. I'm only concerned with
Lords, I'm a small farmer,
encroaching
my
of
lords,
road.
constructing my dwelling house. Now, my lords, for political,
Correct. Now, if you have filed for regularization, you
those
are-
applications are pending, my lords.
Correct, but it cannot, you cannot regularize public ways.
My lords, I have not, my lords, at all constructed, my lords, anything on the public road.
That will ask the government.
Kindly see the merger submitted by the revenue inspector and village accountant, annexure R2 and R3, my lords.
Yes.
Typed copies at page 9, ಇಲ್ಲಿ 7 ಲೈನ್ ಕೆಳಗೆ ಮಚ್ಚಿನ ಗ್ರಾಮದ ಸರ್ಕಾರಿ ಸರ್ವೆ ನಂಬರ್ 199/1 ತುಂಗಪ್ಪ ಸ್ಟೂಡೆಂಟ್ಸ್ ಅವರವರು ಅಕ್ರಮ ಮನೆ ನಿರ್ಮಿಸಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಸಾರ್ವಜನಿಕ ಪಂಚಾಯತ್ ರಸ್ತೆ ಅಸ್ತವ್ಯಸ್ತವಾಗಿದ್ದು ಸದ್ರಿ ಅರ್ಜಿಗೆ ಸಂಬಂಧ ಹಾಳಾಗಿರುವ ಸಾರ್ವಜನಿಕ ಗ್ರಾಮ ಪಂಚಾಯತ್ ರಸ್ತೆಗೆ ಮನೆ ಕಟ್ಟಿರುವುದರಿಂದ ಮಚ್ಚಿನ ಗ್ರಾಮ ಪಂಚಾಯತ್ನ ಸ್ಥಾಯಿ ಸಮಿತಿಯಲ್ಲಿ ಉಭಯ ಪಕ್ಷಗಳ ನೋಟಿಸ್ ನೀಡಿ ತೀರ್ಮಾನಿಸಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶನ ನೀಡಲು ಸನ್ನಿಧಾನಕ್ಕೆ ಕಡತ ಒಪ್ಪಿಸಿದೆ. That is the merger prepared by the
damage caused to the public road ಅಂತ
My
ಹೇಳ್ತಾರೆ.
only
They don't
respect.
say, my lords, I have constructed, my lords, by encroaching.
Just wait.
My grievance is only in respect of encroaching and damaging of panchayat road. It leads to my residence.
Lords, is only, my lords, motivated, my lords, complaint.
No, correct, you take your stand. If you have not encroached.
My lords, I have not at all encroached the public road.
So you file your objections. Government, you find out.
My lords,
I will
meanwhile,
file
my
my
lords,
objection.
I request to maintain status quo, my lords. Once
lords,
construction is completed, my lords, I will lost my right, my lords.
He has no right, my
by
lords.
virtue of stay, he has proceeding
No.
proceed with the construction.
My lords, there is no,
Who appears for the panchayat?
Panchayat is not a party, my lords. It's a revenue land.
lords, kindly see, my lords, the way the order is passed, without hearing me, without providing any opportunity, straight away, my lords, an order of demolition is passed. Lords, when I go and, my lords, seek time to file objections to such
Parties,
notice, my lords,
assistant commissioner and
my lords,
Tahsildar
being
is the
politically
party.
motivated, my lords, in 3 days, my lords, they insist upon me to, my lords, file objections. When I go and take the objection, my lords, they pass an order and say, my lords, you have to vacate the premises within 3 days.
I will request
My lords, I am
only
a small
status
farmer.
quo in respect of road, my lords. I am not praying for his construction. I am only praying before the court to status quo in
Road, my
respect
lords, I have no
of
objection,
panchayat
I am
road.
not coming in the way, my lords, in respect of road. My lords, I am not at all constructed, my lords, anything. I have not encroached the road. I will file my objections.
Merger is very clear, my lords.
Now the Tahsildar, you ask, let both of them appear before you. I'll fix a date.
Yes, ma'am.
If it is, you hear both of them and then you take your stand. Both parties to appear before the Tahsildar on date, for short date. 24th. Relist the matter.
At 11:30 AM.
At 11:30 AM. Relist the matter on 26th. The Tahsildar to look into the grievance raised by the impleading applicant herein that there is encroachment of road. Tahsildar to verify records, hear the parties and file report as regards such aspect by the next date. Yes.
Please.
Till the interim order earlier granted may be extended.
Interim order earlier granted is extended till the next date.
Great.
74.
Respondent number 6, please, my lord. My lord, some urgency in this matter, my lords. I'm led by senior counsel. If I may request for a short part, because there's an injunction virtually operating against me without my objections on record. We've been suffering a lot because of that, my lords. There are a lot of pending registrations. There are a lot of people who've invested a lot of money, and virtually without my objections on record, ex parte was injunction was granted, my lords. I won't say ex parte. Some urgency, my lords, if I may request for a short pass over, my lords.
Hearing the other side only, my lord, this honorable court granted the interim order.
My objections were not on record, my lords. I was served virtually 4 days before the matter was taken up. And I filed an additional statement also, my lords. My colleague may hand over that document, by which it shows, my lords, that these lands were practically government lands and never the lands that at the time when the petitioners are claiming their rights, at that time it was government land.
No, now who is the purchaser now?
Lord,
My lord,
no,
I am
now
developing on the
there is
property
a,
and I have purchased
Lord,
it.
there is an interplay of Land Reforms Act as well as the PTCL Act. Well, what happened was, Lord, this 4 acres of land was granted, my Lord, in the year 1964 in favor of one Sri Honnappa, my Lord. Then he sells the property and ultimately, my Lord, the petitioner purchased it. Then what happened, my Lord? The grantee activated the assistant commissioner, and the assistant commissioner, my Lord, passes an order, resumes the land to the government, and that order, my Lord, came to be challenged by before the deputy commissioner, my Lord. The deputy commissioner confirms the order passed by the assistant commissioner. Against that, my Lord, I am before this honorable court because I was not made as a party. My vendor who sold it long back, my Lord, he was made as a party. He was not served. The notice was said to have been served on the land. And ultimately, the assistant commissioner forfeits the land. Deputy commissioner confirms it. And I am before this honorable court against that. Thereafter, what happens, my Lord? Once the land was ordered to be restored to the grantee by the assistant commissioner, Lord, after some time, the grantee, my Lord, approaches the government, suppressing that the forfeiture by the under the 79. There is a further proceedings, my Lord, under the Karnataka Land Reforms Act. But the assistant commissioner initiates proceedings under section 83 of the Karnataka Land Reforms Act because of the alleged violations of section 79A and B by my vendor, my Lord. Thereafter, my Lord, what happens is the without service of the notice, my Lord, I was not even made as a party. My Lord, the assistant commissioner forfeits the land under section 83. My Lord, that order I challenged before the Karnataka Appellate Tribunal, my Lord. So that appeal came to be dismissed for default, against which I have filed an application for restoration of the appeal and to decide on merits. Lord, that miscellaneous petition is pending consideration. Lord, in the meanwhile, what happens is the grantee, my Lord, who obtained an order from the assistant commissioner, my Lord, under the PTCL Act, applies to the government seeking permission to sell it, Lord, suppressing that forfeiture under section 83 of the Karnataka Land Reforms Act. Lord, as per the understanding, my Lord, without reference to the order of forfeiture under section 83, my Lord, the GPA holder represents the grantee before the government and secures an order permission to sell the land to third parties. Lord, now the person who is opposing my claim is the purchaser after the forfeiture of the land. Lord, therefore, my submission is that there is an interplay and vesting of the land under both the enactment, but that requires consideration. So therefore, this honorable court granted an interim order because otherwise the second purchaser, my Lord, he would he has formed the layout and there was an imminent threat of creating third-party rights, my Lord, making the issues more complex. Therefore, my Lord, considering all these aspects, my Lord, this honorable court granted an interim order that until this is decided, let them not create third-party interest. That is the order, interim order granted. Matter requires consideration, my Lord.
If I may, my
Respondent
lord,
4 and
because
5
what
are still to be served. I will take the steps, my Lord, then final hearing can be taken.
if I may just take a moment, my lords, to explain what in fact had happened. That the very first sale itself was in violation by the grantee within the violation period where they were not supposed to sell. Within that period, the sale was made. And therefore, at the request of the grantee, it was set aside. That sale itself, the very initial sale itself, was in violation of the conditions imposed under the grant, my lords. And hence, at that time itself, there was a reversion. Now, our submission, of course, is, and we have made pleadings as well and filed the order sheet to show that the petitioners were parties. They were very much served before the both forums, DC as well as AC. There is an advocate who has filed wakalat on their behalf, and they have then taken it up in challenge. In the meanwhile, of course, my lords, what has been suppressed before petition, my lords, this I must fairly submit, while a submission is being made across the bench today, what was not before, my lords, when the interim order was passed was this fact. The fact that in 2005, which is well before the PTCL permission was given under the PTCL for sale, in 2005 itself, for violation of 79A and 80, the land had been reverted to the government. And at that time, it was for violation of 79A and 80 by the predecessors entitled to the petitioner. This entire fact, my lords, has been suppressed in the petition. My lords did not have the benefit of this fact when the interim order was passed. Therefore, under 79A and 80, it had gone in 2005 itself as government land, my lords. Till 2014, there is no challenge by the petitioner. There is no mention of this before my lords in the petition. I am bringing it now in before my lords in the additional statement of objections. So this was not, it is not correct to say that my lords had thought this requires further consideration and therefore interim order was passed. In fact, my lords had not considered this point, my lords.
Let us see, both of you please look into the judgment of the apex court, which
Please,
appears to indicate that omission of 79A and B dates back to the day of the
1974.
all proceedings abate. That is the latest one. Have a look at
Please,
it.
my lords, we have judgments as well on that, my lords.
What implication it will have? It's a recent judgment.
Yes, my
Please,
lord,
my
I will.
lords.
But she is the purchaser during the pendency of my appeal.
Let us see.
So pendency, how, my lords? 2005 till from 2005, the title is clear. It shows
Let us see.
government land and
But
then
you examine now in light of the judgment of the apex court, if everything abates, it abates. Apex court has held that since it dates back, proceedings have to go. So
No,
have
my
a look
lords,
at it.
I'll of course examine, my lords, but my understanding is that the order itself, the KAT also, my lords, their appeal has been dismissed for non-prosecution. That again is not being submitted before this honorable court. As
Miscellaneous
on date,
petition
their
is filing.
appeal has been dismissed for non-prosecution. They have made an application for restoration, but the
Yes.
appeal has been dismissed for non-prosecution. As on date, it is
true.
government
That is-
land. That reversion has not been disturbed.
Let us see.
My lords, my
will take
difficulty is this,
Lord
my
for
lords,
respondent
that
four
the
and five.
interim order continues, my lords. May I only request for a slight modification if my lords permit.
2025 matter, you'll have to wait. It's a
My lords, the urgency is,
They
my
have
lords,
older-
we
they
have,
older
my
matters.
lords, vendors
They have
there who
older
are
matters.
ready to take possession, my lords.
No, that's a
This is
different matter.
only after we
You will have
started
to-
developing that these petitions have come,
There
my
has to
lords.
be full adjudication.
May
Steps
I
to petition
request for one indulgence from this honorable court, my lords? There are certain agreement to sell holders, my lords, already who we received, and we were going to only register the sale deed. If only those may be permitted, my lords, I'll be obliged. I can give the details as well.
This will have to be decided only then either of you can go ahead.
I request for tomorrow, day after, if that's convenient, my lords, because we'll examine this judgment, my lords, and get back because
9th, but you have a Sheshua, the judgment one.
I will collect it. Lord, the
I request for the coming week at least, my lords, the week of 24th, if
Let
that's
us see,
convenient, my
you
lords.
have a look at it. If that is the order of the apex court, land reforms proceedings go for a 6.
Date.
My lords, the week of 24th, if that's convenient, my lords.
No, let us see. You get ready on the main, both sides to file their synopsis. Yes.
Please, my lords.
Pass over matters. Serial number 9. Sridhar K.
Relist date for this.
24th. Serial number 27. Leela P. AG.
Yes, Your Lordship, I appear for petitioner.
The present petition has been filed seeking for a direction to the respondents. to give effect to the directions passed in WP 46894-46897 of 2017. This court, while disposing of the writ petition, had directed that the process of conducting survey and fixing boundaries of the scheduled property was required to be completed in terms of their application dated 7/7/2014 expeditiously. This the coordinate bench, while disposing of the writ petition, had directed process to be completed within 6 months from date of receipt of this order. AGA, upon instruction, submits that the process is underway, the process of survey and fixing of boundaries. The process of survey is complete. However, consequential action is required to be taken. It submitted that remaining work of fixing of boundaries would be completed within a period of 2 months.
We will produce, my lord.
That I do, you sort it out amongst yourselves.
Because we have the copies, my lord, because we can.
That's up to you and accordingly, in light of the stand of the state, the petition is disposed of. What is the, what is the situation you are asking them to give the record? What is this? That's why you do some scanning or digitizing. Yes.
30, Yashodhara Health. 30.
You have no manner of
Petitioner.
verifying what they give is correct or wrong. Yes.
Hello, it was petition for mandamus, my lords. In this matter, what has happened is
6 weeks.
The petitioner. So at least now you must pull up your socks. You must digitize what is filed.
Yes.
And whatever the old records also must be digitized. Prevent tampering, manipulation. Some project kind of process should be done, and at least prospectively at all places it must be immediately digitized. Applications are filed, any of online, etc.
Yes.
So the legacy of records will have to be taken up by the government.
Yes, sir.
The petitioner has sought for issuance of writ of mandamus to direct the respondent to consider and dispose of petitioner's representation at annexure A in terms of the representation at annexure A. Petitioner has sought for effecting poverty kata in his name. Full stop. AGA submits that the representation at annexure A to be considered and orders passed as per law within a period of
6 weeks.
6 weeks. Accordingly, taking note of the stand of the state, petition is disposed of.
61. Serial number 61. Muthura.
Appearing for petitioner. My lord.
Yes.
This petition is filed to set aside the order of the respondent number 1 in annexure G, wherein without considering the available documents and the kata was already transferred in the name of the petitioner, has set aside the order and has restored the kata in the name of respondent number 5. Now, I would like to adduce some of the documents pertaining to the thing along with synopsis. So,
Now the state has taken their stand.
I am in possession by virtue of sale deed executed right from 1965. The flow of documents starts from 1965, my lord.
No, whether the state has taken their stand.
Okay. No, but
Is it required?
not.
It's an interstate dispute.
Yes.
It's only based on revenue documents, the whole matter is going on in this matter, my lord. Now, my learned colleague has filed some of the documents on previous occasion, which can be seen that the respondent number 5 has purchased the property from one Mr. Sridhar, who has purchased the same from the children of Muni Veeramma, that is Munishamappa, stating that the land was granted under Inam Abolition Act. Now, coming to the said fact, I would like to draw your kind attention towards the document adduced by my learned colleague today morning, my lord. If it is taken in annexure 15.
Now, first you tell me who went before the assistant commissioner first.
There are two sets of litigations happened in the revenue department. In one set of litigation, the document is been ordered in favor of the petitioner's flow of documents, and in another set, it has been ordered in favor of R5 name.
Both by the DC.
Both on the same, but there is a ambiguity with the order itself if considered with the R5 documents. That's why I would like to bring to the kind notice of this honorable court, my lord.
Now you are challenging the order of?
Order of, in annexure G, order of R1.
Assistant commissioner.
No, it is the DC.
Yes.
In annexure G, my lord. The assistant commissioner and the Tahsildar had ordered the kata to be effected in the name of the petitioner on virtue of sale deeds executed from the year 1965. And finally, the petitioner had purchased from R4 the said property, and accordingly the kata was transferred in his name by the order of the AC. Later on,
AC order at annexure?
AC order.
Annexure H.
Yes, my lord. Just AC order in RP. Yes, annexure. AC order in RADH 165 of 2017. RADH 165 of 2017, my lord. That's in annexure H.
That was filed by?
Filed by R4. R4 against the Tahsildar and R5.
That petition was filed seeking?
Seeking to transfer the kata in the name of the petitioner, that is R4 herein, on the virtue of sale deed got executed by him.
Sale deed executed by?
Sale deed, he purchased the property from one Muni Venkatamma.
The earlier mutation that was challenged was?
The mutation that was challenged was in RRTCR 227 is there, my lord.
MRH 15.
15 of 2013-14.
Now that was standing in whose name earlier?
Muni Venkatamma.
So after her sale deed,
After that sale deed, R4 got the kata transferred to his name on the basis of this order. In annexure H.
yes.
Later on, the same order was set aside by R1 without considering the fact. Here, I would like to draw your kind attention, my lord, towards the order part, wherein
There are no suits pending, or still suits are pending.
as of now all suits have been disposed of, my lord. All suits have been disposed of.
No proceedings are pending before the civil court.
No, my lord.
His
As of
vendor
now,
suit and the appeal have been dismissed on merits.
no.
No title.
Vendor's suit was a partition suit which was in which respondent number 5 was a party. But that was dismissed on merit on the basis of the document of R4.
Now the AC order had directed for effecting mutation to the
In name of R4, my lord.
Tippaya on the basis of the sale deed.
Yes. Later on,
Now this, who are you?
I am the petitioner who purchased the property from Mr. Tippaya and got the kata transferred in the name of the petitioner.
What happened before the deputy commissioner?
Deputy Commissioner has set aside the AC order, hence this petition has been filed to set aside the said order. Considering the documents that, I would like to draw your kind attention, my lord, towards the document adduced by R5 itself. On the previous date, there are some of the documents adduced.
On what ground the deputy commissioner sets aside?
It is set aside that there was one petition in which R5, the kata was transferred in favor of R5 under petition 129 of 2006-7. Revision petition number 129 of 6-7.
I have produced annexure R14, my lord, for you also. That order.
Yes, now you take me through your synopsis, whatever you have prepared.
My lord?
Take me through your synopsis.
Yes, my lord. My synopsis. The first one is that on 27/5/1965, the first sale deed was executed by Dodda Gurappa son of Arsnalli Nagappa Bovi in the name of Muni Gurrama. The said Muni Gurrama's name was also there in column 12 of the RTC, which I have produced in document number 10, my lord, along with my synopsis. It has stood up to Muni Gurrama's name has been continued in the Pani RTC till the year 83-84. Later on the basis of one alleged case in Inam abolition, they have got the entries changed. Now coming to later on after 1965, on 8/7/2008, Muni Venkatama got the Pani in her name and she has executed a sale deed, gift deed in favor of her husband on that date. Afterwards, on 24/3/2010, the same gift deed was reversed in the name of Muni Venkatamma by her husband.
Who is Muni Venkatamma?
Muni Venkatamma claims to be the legal heir of Muni Gurama.
Yes.
Later on, these two gift deeds gets executed. Afterwards, on 29/4/2011, R4 gets a sale deed executed in his favor from Muni Venkatamma. That is in annexure.
Yes. Then next.
Hello?
Then
After that, the legal heirs, other legal heirs of Muni Venkatamma brothers, on 8/8/2011 have executed a consent deed confirming the sale deed in favor of Tipaya. That's in document number 6. Document number 6.
Yes.
Next, on 11/7/2018, Tipaya filed the petition to transfer the kata in his name, and accordingly, Annexure H, in Annexure H, Tipaya got the kata transferred to his name on the basis of that order. Now, I would like to draw your kind attention to one of the document on the basis how Annexure H was allowed. It is in document number 2 in my synopsis, my lord. Document number 2, page number 5, which has clear discussion of all the transactions happened in the issue of this property. I would like to draw directly one issue where R5 claims that she has got the property on the basis of Inam Abolition Act. To that, there is a finding by the Tahsildar that there is an ambiguity in MR number 25/8889. I would like to read out in page 8. This para clarifies whether Inam abolition was in order or not. Page number 8, my lord. If permitted, I will read out only this para. Para second. ಮತ್ತೊಂದು ಭಾಗದಲ್ಲಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳಂತೆ ಕುಂದಾಣ ಹೋಬಳಿ ದ್ಯಾವರಳ್ಳಿ ಗ್ರಾಮದ MRH 25/88-89ರಂತೆ ಇತರೆ 3 ಜಮೀನುಗಳ ಜೊತೆ ಸರ್ವೆ ನಂಬರ್ 77/1ರಲ್ಲಿ 2 ಎಕರೆ 24 ಗುಂಟೆ ಜಮೀನು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ವಿಶೇಷ ತಹಶೀಲ್ದಾರ್ ಅವರ ಸಾಹೇಬರ 4/59/60ರಂತೆ 15 ವರ್ಷಗಳ ಪರಭಾರೆ ಮಾಡಬಾರದೆಂಬ ಷರತ್ತಿಗೆ ಖಾತೆಯನ್ನು ಮುನಿವೀರಮ್ಮ ಕೊಂ ನಾಯಕರ ಅಪ್ಪಯ್ಯ ಅವರಿಗೆ ಖಾತೆ ಮಾಡಲಾಗಿದೆ. ಪ್ರತಿವಾದಿಗಳು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಮುಂದೆ ನಡೆದ ಅಪೀಲು ಪ್ರಕರಣದಲ್ಲಿ ಸದರಿ ಜಮೀನು ತಮಗೆ ಇನಾಮ್ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಪ್ರಕರಣ ಸಂಖ್ಯೆ 4/59/60ರಂತೆ ದಿನಾಂಕ 29/7/67ರಂತೆ ಆದೇಶವಾಗಿರುವುದಾಗಿ ಮತ್ತು ಸದರಿ ಜಮೀನಿನ ಖಾತೆ MR 2588-89ರಂತೆ ಆಗಿದ್ದು IHC 32/89-90ರಂತೆ ಪಾವತಿ ಖಾತೆ ಒಬ್ಬನೇ ಮಗ ಮುನಿಶಾಮಪ್ಪನವರ ಹೆಸರಿಗೆ ಆಗಿರುತ್ತದೆ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ಈ ಮುನಿವೀರಮ್ಮ ಕೊಂ ನಾಯಕರ ಅಪ್ಪಯ್ಯ ನಾಯಕರ ಜಾತಿಗೆ ಸೇರಿದ್ದು ಎಂದು ಕಂಡು ಬರುತ್ತದೆ. ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕೊಟ್ಟಿರುವ ಹೇಳಿಕೆಯಂತೆ ಪ್ರತಿವಾದಿಗಳು ಸದರಿ ಜಮೀನಿನ ವಿಶೇಷ ಇನಾಮ್ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶ ಪ್ರಕಾರ ಮಂಜೂರಾಗಿರುವುದು ಎಂದು ಹೇಳಿದ್ದು, ಇವರು ಉಲ್ಲೇಖಿಸಿರುವ MR 25/88-89ರಲ್ಲಿ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ವಿಶೇಷ ತಹಶೀಲ್ದಾರ್ ಸಾಹೇಬರ 4/59/60 ಎಂದು ಬರೆದಿರುವುದು ಒಂದಕ್ಕೊಂದು ತಾಳೆ ಇರುವುದಿಲ್ಲ. ಇದು ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಆಗಿರುವ ಆದೇಶದ ಮೇರೆಗೆ ಮಾಡಿರುವ ಖಾತೆ ಎಂದು ಭಾವಿಸುವುದಾದರೆ 1959-60ರಲ್ಲಿ ಈ ರಾಜ್ಯದಲ್ಲಿ ಯಾವುದೇ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಅಸ್ತಿತ್ವದಲ್ಲಿರುವುದಿಲ್ಲ. ಇನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಮುಂದೆ ನೀಡಿರುವ ಹೇಳಿಕೆಯಂತೆ ಈ ಜಮೀನು ಇನಾಮ್ ರದ್ದಿಯಾತಿ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶದಂತೆ ಮಂಜೂರಾಗಿರುವ ಜಮೀನು ಭಾವಿಸುವುದೇ ಆದರೆ ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ MRH 25/88-89ರಲ್ಲಿ 15 ವರ್ಷಗಳ ಪರಭಾರೆ ಮಾಡಬಾರದೆಂಬ ಷರತ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ. This clearly states that Inam Abolition Act prakara this property was not acquired, only a created document. I would like to draw your kind attention to my lord towards the document adduced by respondent number 5 on previous occasion as annexure R1. Previous occasion, they have.
No, but now government stand is not required, is it?
But may I submit, Lord, it is an admitted fact that on 1/2/1959, by virtue of section 14 of the Personal Miscellaneous Norms Abolition Act, the provisions of the Personal Miscellaneous Norms Abolition Act was made applicable by notification of 13/1/1959, whereby it stood vested by, as your lordships are aware, section 3, consequences of vesting, free from all encumbrances, everything. My earliest vendor, was the only grantee. She was registered as a tenant and a permanent tenant in section 5. That is what R1 which I have placed on record. That is granted in 59/60. The question before your lordships ultimately is this: it admittedly, when it is a Kayam Gutta village to which the Personal and Miscellaneous Norms Abolition Act apply, what is the right of the petitioner and so-called his vendors who did not even apply, who were never granted any occupants, who were not registered as occupants firstly? Thereby, as your lordships are aware, the law is settled on the point by division benches of this honorable court, several judgments, and that is the law, and by the apex court also. With respect to the Inam land, once it is vested, under section 10, they had to make an application depending on the tenure, type of tenure, they had to get registered as a permanent tenant, quasi-permanent tenant, or other tenant, or ordinary tenant.
No, but now the government can take their stand.
They can take, it's an Inam village, that can't be a disputed fact. Now, they have not questioned the Inam's order. Today it is too late. He can't say that we are before this honorable court against the order under 136(3) of the Land Revenue Act. He filed his predecessor filed suits. Suits have been decided, dismissed. Fraudulently, they have created those sale deeds. That's what the finding also, which has attained finality. Ultimately, the law and the point, as your lordships are aware, the full bench judgment in Dayamas case also by this court, where once the civil decrees are binding on him, he is a purchaser during the pendency of the suit. He is it by the 2004 volume 2 SCC apex court holds it, which I'll place that authority for your lordship's consideration. Whereby I put a question to myself: what is his right? Civil court, he has lost. His predecessor lost. The matter was listed for judgment on 13/8/2018. He creates a sale deed R4 in favor of the petitioner. 1/9/2018, the judgment is pronounced by the London district judge dismissing his suit with cause, and that attained finality. Thereafter, I had already challenged it before the revision, before the deputy commissioner in the meantime, because the deputy commissioner had already passed an earlier order, which I placed under annexure R13, directing the Tahsildar to effect the Khata. The assistant commissioner sits in appeal over the order of the deputy commissioner, passed under 129/63. Please.
Yes, continue.
Please.
Yes, my lord.
Continue.
Now, even if the document in annexure R4 seen, my lord, wherein my colleague is stating that the suit was dismissed. If at all seen at the order of Order 7 Rule 11, the reason adduced by the trial court is that, I would like to read out in page number 3 of the judgment in R4. R4, page number 3, the reasons. R5 has not submitted any of our documents to prove our ownership or get the suit dismissed. It is only dismissed on the strength of the document of R4, who was as on that date said to be the owner of the property by virtue of getting executed sale deed by Muni Venkatramma. The reasons, my lord. Page 3 in the judgment, 23, page 23. In page 3, page 23, point number 1, reasons stated. It is the specific prayer of the applicant defendant number 9. Defendant number 9 is none other than annexure R4 submitted by respondent.
Internal page, it starts at page 26.
21, my lord.
26.
26, sir. It's 21 written.
Internal page.
Sir, 21.
R4 is.
No, not today's. Previous one.
Previous only, 26.
But it is written 21 here.
Sorry, there may be a
Okay.
mistake.
In page, it is R4 in page 3 of the judgment order.
Now this is a suit between
this Muni Venkatama and her family members, in which R5 was the defendant number 9.
Now you claim title through Tippaya.
No, yeah, Tippaya, my lord. Yes, from Tippaya, and Muni Venkatama has sold to Tippaya.
Now this OS 302 of 97.
Yes, my lord. In this, Tippaya is not the party.
Suit for?
My lord?
Suit for?
Partition.
Next, R7 have produced the plaint. Your Lordship directed me to place it on.
Today will be on this. Yes. In today's document, annexure R7 is the plain copy of the said suit, my lord.
Suit was dismissed on the ground that
Tippaya has got the sale deed executed in his name. The plaintiff is playing fraud upon the court. The applicant has also produced the copy of the sale deed dated 29/4/2011, and going through the sale deed, it is clear that the plaintiff has sold the entire suit scheduled property in survey number 17/1 measuring 2 acre 13 guntas of Devrali village in favor of one Tippaya.
So because she didn't have any subsisting interest as having sold to Tippaya,
yes, my
court
lord,
said you don't have.
Suit got dismissed. And R5 has not produced any of her documents to prove her ownership of the property in the said suit.
Yes, then what happened?
Then afterwards, Tippaya sold to this petitioner, and this petitioner had got the kata as per annexure H. Later on, the respondent number 5, in collusion with respondent number 1, has got ordered in setting aside the order of annexure H.
What is the DC? What does the DC say?
The concerned DC in annexure H states that there was already a petition in 129 of 2006-7 dated 23/8/2013 ರಲ್ಲಿ ನೀಡಿರುವ ಆದೇಶದಂತೆ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಲು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ತಹಶೀಲ್ದಾರರಿಗೆ ಸೂಚಿಸಿದೆ. Which is on the backdrop in 2013 only, R5 had got this order. She has not produced even in OS suit in OS 302 of 2000.
You read at page 82, second paragraph.
80?
Page 82, second paragraph.
ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳ ವಾದ, ಅವರು ಸಲ್ಲಿಸಿದ ದಾಖಲೆಗಳು ಮತ್ತು ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಯಿತು. ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಕುಂದಾಣ ಹೋಬಳಿ ದೇವರಹಳ್ಳಿ ಗ್ರಾಮದ 17/1 2 ಎಕರೆ 13 ಗುಂಟೆ ಜಮೀನು ಇನಾಂ ರದ್ದಿಯಾತಿ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಂದ ಪ್ರಕರಣ 4/59/60 ಶ್ರೀಮತಿ ಮುನಿವೀರಮ್ಮ ಎಂಬುವರಿಗೆ ಮಂಜೂರು ಆಗಿರುತ್ತದೆ. ಇವರ ಮಗ ಮುನಿಶ್ಯಾಮಪ್ಪ ಎಂಬುವರು ಈ ಜಮೀನನ್ನು 14/5/93 ಶ್ರೀ ಶ್ರೀಧರ್ ಎಂಬುವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಶ್ರೀ ಶ್ರೀಧರ್ ಅವರು ಈ ಜಮೀನು ಶ್ರೀಮತಿ ಬಿ.ಕೆ. ಲಲಿತಾ ಅರ್ಜಿದಾರರವರಿಗೆ 24/3/94 ಮಾರಾಟ ಮಾಡಿದ್ದು, ಇದು ಉಪ ನೋಂದಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಲ್ಲಿ ಕ್ರಮಾಂಕ 2012 93/94 ನೋಂದಣಿ ಆಗಿರುತ್ತದೆ. ಕ್ರಯಪತ್ರದಂತೆ MR 10 93/94 ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗಿರುತ್ತದೆ. I would like to draw your kind attention to this specific kata, my lord. The document is submitted in R2 by the R2, R1 only, along with the order of the Inam. Second sheet, if at all seen, RTC ಯಲ್ಲಿ ತಾಳೆ ಇರುವುದಿಲ್ಲ, ಸಂಬಂಧಿಸಿದವರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಮುಂದಿನ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು. Specific note is there in this said MR that there is no RTC ತಾಳೆ ಇರೋಲ್ಲ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. Even then that is being considered by the R1, and documents itself speaks. ಅನೆಕ್ಷರ್ 1 ಫಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. R1 ನಲ್ಲಿ ಸೆಕೆಂಡ್ ಶೀಟ್. MR 10 93 94. ನನಗೆ ಬಂದಿದ್ದು ನೀವೇ ಕೊಟ್ಟಿದ್ದು ಸರ್. ಇನ್ನೊಂದು ಹೇಳ್ತೀವಿ. ಓಕೆ R3. ಇಲ್ಲ R1 ಇದೆ, R2 ಇಲ್ವಲ್ಲ, R3 ಎಲ್ಲ ಇದೆ. ನಾನು ನೋಡ್ಬೇಕಾಗುತ್ತೆ.
ಎಸ್
ಹಾ ಉಲ್ಟಾ ಇದೆ. R3 ಮಾರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಫಾರ್ಮ್ 11 ಮ್ಯೂಟೇಶನ್ ರಿಜಿಸ್ಟರ್. ಇದರಲ್ಲಿ 17/1 17/3 RTC ತಾಳೆ ಇರುವುದಿಲ್ಲ. ಸೇಮ್ ಇನ್ 93 94 ಓನ್ಲಿ ತಾಳೆ ಇರುವುದಿಲ್ಲ. ದೇರ್ ಇಸ್ ನೋ detailed enquiry conducted in this aspect, or nowhere there is any discussion as to this, how the RTC got later on corrected. Yakendre, even if the order of Inam abolition is seen, the total extent of the property was 2 acres 24 guntas. 2 acres 24 guntas. There was no 2 acres 13 guntas at all. 2 acres 13 guntas right from 1965. From Munigurama it has continued even in Pani and all sale deeds. But here Inam abolition states 2 acres 24 guntas. Even there is an ambiguity, my lord. If read out, if my lordship permits to read out the case number 59 of 60, 5960, in case number 4, there is a cut. They have cut off the word. The petitioner is shown as registered occupant in settlement register. As per Inam Abolition Act, whenever the premium is waived off as per the act, such occupant should be shown in the settlement register. Here they state that as per section 5 of the act, premium is waived off, but they cut down the sentence that the petitioner is shown as registered occupant in the settlement register. Until
now, let us see how he defends the order of the deputy commissioner. I'll come back to you.
Yes, my lord.
Yes, please. I'll have to rise by 4:45 if it's possible. Otherwise, we'll have it some other day.
Then 20th, day after tomorrow.
Not day after tomorrow. Any other day, sir. Day after tomorrow is okay. Or tomorrow is okay. Day after tomorrow. I have.
I'm traveling tomorrow.
Monday.
Much obliged.
This is the matter. Same stage on Monday.
Much obliged.
End of this matter. Nagaraj RC.
And for the petitioner. In this case, my lord. Kindly see the annexure E, my lord. Annexure F, my lord. Sorry, annexure F. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗುಂಡ್ಲುಪೇಟೆ ತಾಲೂಕು ಪೇಜ್ ನಂಬರ್ 23 my lord.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಗುಂಡ್ಲುಪೇಟೆ ತಾಲೂಕು ಬೇಗೂರು ಹೋಬಳಿ ಶಿಗವಾಡಿ ಗ್ರಾಮದ 132 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಸುಮಾರು 70 ವರ್ಷಗಳಿಂದ ವ್ಯವಸಾಯ ಮಾಡಿಕೊಂಡು ತನ್ನ ಸ್ವಾಧೀನದಲ್ಲಿದೆ. ದಿನಾಂಕ 5/1/2019 ಅಕ್ರಮ ಸಕ್ರಮದಲ್ಲಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ನೋಂದಣಿ 30/15 ಆಗಿದ್ದು, ಇದಕ್ಕೆ ನಕ್ಷೆ ತಯಾರಿಸಿ ಗ್ರಾಮ ಲೆಕ್ಕದಲ್ಲಿ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕ ಅವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಜಮೀನಲ್ಲಿ ತೆಂಗು ಬಾಳೆ ಬೆಳೆಯನ್ನು ಬೆಳೆದಿದ್ದು ವ್ಯವಸಾಯ ಮಾಡಿಕೊಂಡು ಹೋಗಲು ಕಂದಾಯ ಅಧಿಕಾರಿಗಳಿಂದ ತೊಂದರೆ ಆಗದಂತೆ ಮಾಡಿಕೊಡಲು ಕೋರಿ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
ಅದರಿಂದ ಉಲ್ಲೇಖ ಮನವಿಯನ್ನು ಈ ಕೂಡ ಕಳಿಸುತ್ತ ಗುಂಡ್ಲುಪೇಟೆ ತಾಲೂಕು ಶಿಗೇವಾಡಿ ಗ್ರಾಮದ 132ರಲ್ಲಿ 30 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಾಗುವಳಿ ಕೋರಿ ನಮೂನೆ 57ರಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ನಿಯಮಾನುಸಾರ ಅಗತ್ಯ ಕ್ರಮಗಳು ಕೈಗೊಂಡ ಕ್ರಮದ ಬಗ್ಗೆ ಅರ್ಜಿದಾರಿ ಮಾಹಿತಿ ನೀಡಿ ಕಚೇರಿಗೆ ಮರದಿಯನ್ನು ಸಲ್ಲಿಸಿದೆ. In return, Lord, Tashildar has given a report. Kindly see the page number, annexure G, typed copy, Lord. Page number 25. ಕೊನೆ ಲಾಸ್ಟ್ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಕೊಳ್ಳೇಗಾಲ ವಿಭಾಗ ಬೇಗೂರು ಹೋಬಳಿ ಶಿಗೋಳಿ ಗ್ರಾಮದ 132 30 ಗುಂಟೆ ಜಮೀನನ್ನು 70 ವರ್ಷಗಳಿಂದ
What has happened to this application?
Now, my lord, they have given a report. They are sought for report from the village accountant. They have given a report, my lord. Kindly see the annexure H, my lord. Last line, my lord. Last line. RTCಯಲ್ಲಿ ನಮೂದಾಗಿದ್ದು ಸರಿ ಅಷ್ಟೇ. ಸದರಿಯವರಿಗೆ 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಅಕ್ರಮದಡಿಯನ್ನು ಮಂಜೂರು ಮಾಡಬಹುದಾಗಿ ಸದರಿ ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಸಲ್ಲಿಸಿದೆ. Kindly see the annexure A, my lord.
So it's still pending.
Still pending, my lord.
Rejected.
Connection, annexure A, my lord.
Rejected, my lord.
Annexure A.
Petitioner's application. Lordships would find that serial number 82, 30 guntas and survey number. Pursuant to the rejection is when we've issued the impugned notice, my lord. The report referred to in the endorsement is dated 12/5/2025.
In annexure, they have not stated anything about the.
Copies.
This is 15/12/23, Lord, Tashildar order. Lord, report, Lord, 23/20/24, Lord. In the year 24.
On what ground it was cancelled?
The land is Gundu Topu, my lord. Gundu Topu cannot be regularized.
I've been position of for the last 70 years.
If it is classified
Kindly
as
see the
Gundu Topu, it
photograph,
cannot be
Lord.
Let him challenge it. We'll protect him till then. We'll protect you. You challenge this proceedings.
Yes, Lord.
We'll
Till then, Lord, till then.
I'll protect you for a period of 4 weeks, within which you take appropriate proceedings.
The Lordship, kindly see the annexures, photographs. How?
Let us see.
Photographs of the page number 18, Lord.
Let us see. The present petition has been filed seeking for setting aside of the notice dated 28/10/2025 issued under section 104 of the Karnataka Land Revenue Act. Full stop. The said notice directs the petitioner to evict and hand over vacant possession. Full stop. Petitioner has averred in his petition that proceedings have progressed as regards his application for regularization, and till such application, till a decision is taken, the present notice at annexure A is illegal and without authority of law. AGA furnishes copy of proceedings of the Deputy Commissioner dated 18/7/2023, which would indicate that the claim of the petitioner has been rejected on the ground that land regularization of which is sought is a Gundu Topu, within brackets, full stop. Counsel for the petitioner submits that the said order was not communicated to him.
Yes, Lord.
And it's for the
Otherwise,
first,
Lord, annexure it is reflect
and it's
definitely.
for the first time that he has been made aware of the said order. Full stop. Next. Taking note of the said assertion of the petitioner, it would be appropriate to grant liberty to the petitioner to challenge the order of the Deputy Commissioner dated 18/7/2023. In light of the specific assertion that the order of the Deputy Commissioner has not been communicated, if the petitioner were to file an appeal as against such proceedings of the Deputy Commissioner within
2 months.
file an appeal against this order.
In meantime, I will file it. 2 months maximum period is.
You have to file within 4 weeks. I'll grant stay for
2 months.
6 weeks. In between. Within a period of 4 weeks.
And it may be 6 weeks, my lord. I will take all the way documents.
Within 6 weeks, the appeal to be entertained without raising any objection regarding delay. Full stop. There would be an interim order there would be the notice at annexure A would be kept in abeyance for a period of 8 weeks from today. It's made clear that the protection granted would be in force if the petitioner were to file an appeal within the time as stipulated in the order. Needless to state, if proceedings are initiated by the petitioner to challenge the order of the Deputy Commissioner, the proceedings at annexure A would be kept in abeyance till conclusion of such proceedings. All contentions are kept open. Accordingly, petition is disposed of. AG accepts notice for response 1 to 4.
Direct the government to.
Yes, please intimate.
Number 2, S.C. Shivaraman.
I appear for the petitioner, madam. Cases regarding rehabilitation of people who lost their lands in the Sharavati Valley project.
List along. The fresh matter.
It hasn't been furnished to us, madam.
A list along with the WP number.
List to 2. Serial number 40, Manivandan.
As a last opportunity, weeks time granted for compliance.
41.
No representation on behalf of the petitioner. Made clear if the petitioner does not comply with office objections by the next date, court would be constrained to pass orders. Matter was called in the morning session. There was no representation. When the matter is called once again at 4:40, there is no representation. List the matter in the orders list for dismissal on. Dates you can make request to the court officer. Dates will be given.
Mandamus.
Mandamus, if wherever there are mandamus matters, you write mandamus and give. I'll have it in the preliminary hearing list. You write on top that it's only a mandamus matter, and you give the memo to the court officer. It will come in preliminary hearing.
Serial number 76, Agency of Land and Tools.
Dates will be given.
Serial 75.
Make a request to the court officer. Dates will be given. Those matters which are only mandamus, you make a memo and give it to the court officer. It will come in preliminary hearing.